Crime in Court. My name is Heather, and this is the 1996 Menendez brothers trial. We have streamed through the 1993 trial, which ended in a mistrial. This is now their retrial, and we have all new people except for the judge and one of Eric's attorneys. Other than that, I mean, it's the case is going similarly, but kind of the same. I mean, it's so far we have only gotten into, unfortunately, we don't have video, so I am reading the testimony, and we've only gotten into the opening statements, and then we are just finishing up right now the end of lead detective Leslie Zoeller's testimony. So we'll get into that in just a minute. But before we do, I wanted to read this article to you because this is breaking news that just came out this week. So, February 3rd, prosecutors who said the Menendez brothers should go free allege retaliation by DA Hochman. So, as you know, or maybe you don't know, but there is a new DA that is in charge of Los Angeles County, which is where the brothers are under that jurisdiction. And they so before it was George Gascon, who was the DA right before him. He was the one that petitioned for this, but there were individuals in his office that were kind of pushing for that. So those are the two prosecutors in that office are going to be the ones that they're talking about here. So those two that were pushing for this resentencing for the brothers, they had demotions and things like that. So let's get into it. So DA Hochman it doesn't seem like he's going to be very open or receptive to the idea of letting the brothers out. He first came on saying like he's going to be open and look at everything, and then he just keeps delaying like they always do, and politicizing the case and making the brothers just political pawns in his world of politics and rubbing elbows with people. So he's not going to make a decision probably in our favor to have the brothers resentenced. But good thing it's not in his hands entirely. There are two other judges that will be looking at either the resentencing or the habeas to get a new trial or uh, change their conviction. All right, so two Los Angeles County prosecutors who recommended the Menendez brothers be freed from prison alleged that they were punished by District Attorney Nathan Hochman and defamed online by one of his political allies, according to a letter reviewed by the Times. We're not going to read this whole article, but just the portions relevant to this part with the prosecutors. This is the Los Angeles Times. So Brock Lunsford, who oversaw the district attorney's resentencing unit, and Nancy Theberge filed notices of claim Monday that they intend to sue Hochman and Deputy District Attorney John Lewin for retaliation, defamation, and discrimination. The district attorney's office declined to answer questions about Lunsford and Theberge's allegations. Lewin, who recently joined the trial team prosecuting rap star A$AP Rocky, oh really, let out a polite laugh when asked about the allegations outside the courtroom Monday morning. He says, "I'll let the facts do the talking." Lunsford and Theberge said that they made a presentation last October arguing Erik and Lyle Menendez should be resentenced in the 1989 homicides of their parents Jose and Kitty because their imprisonment no longer served the interest of justice. I mean, isn't that what you're here for, DA Hochman? Aren't you here to serve the interest of justice, not political, not politicizing certain high profile cases to your benefit? So the case gained renewed attention in recent years following the release of a Netflix documentary and the filing of a writ of habeas corpus that pointed to new allegations of the SA by um, Jose. After the homicides, the brothers claimed that their father was essaying them, but they were not allowed to present evidence of that allegation in their second trial. The brothers were ultimately convicted of homicide with special circumstances and sentenced to life in prison without the possibility of parole. There is this new rule in, I don't know if it's California or everywhere, but basically, like, the more we know, our laws change. They shape. There's our laws are shaped on the information that we know at the time. It's okay that laws change. It takes forever to get them changed, but eventually they do. And in this case, we now know that the brain isn't fully developed until like 24, 25, sometimes later for men. So the law changed that people who were incarcerated under the age of 25 can't be uh, uh, can no longer be given life without parole, as long as they meet certain factors, and the brothers do. And there's a reason why we should be open-minded to changing errors of the past. But it seems like the justice system is so reluctant to correct the past with the current, with being able to do something for the people who are actually affected by it. Usually it's like a law changes and it benefits people in the future, but not the people from the past. So it's rare that someone can actually, like the brothers, are up for resentencing, new trial, all this stuff after they've exhausted all their appeals. It's not always, this doesn't usually happen. So after the homicides, the brothers claimed that their father was essaying them. The brothers were ultimately convicted of the homicide with special circumstances. Lunsford and Thurberge's memo, which led ex-district attorney George Gascon to file a petition with the court of the brothers' on the brothers' behalf last year, could lead to their being resentenced on a lesser routine homicide charge, making them eligible for parole, as we know. So some high-ranking LA County prosecutors disagreed with the move, including Thuberge and Lunsford's supervisor, according to the notice of claim. Hochman announced his intention to review the decision after handily defeating Gascon last November. He was like he was beat bad, unfortunately, for him. I think he got the brunt of, too much crime and other things rampant going on, and so he just got the brunt of, because he's not as harsh on crime, that he got sent out of office. I don't know anything about his politics or anything. I believe he's Democrat. I believe Hochman is too, or maybe he's an independent, but I'm not really sure. Anyways, doesn't matter. Moving on. So Lunsford, who has been with the district attorney's office since 2000, said he was reassigned to an undesirable position as a calendar deputy in the Norfolk courthouse after Hochman won. So Lunsford, one of the individuals who was outspoken about the resentencing of the brothers, as soon as Hochman gets into power, he sends Lunsford to basically a desk job, I think, a calendar deputy. What are you doing? Like scheduling for others is what I'm assuming that means. I have no idea. But to me, it doesn't sound good. That's a negative connotation, whatever calendar deputy means. All right, so the Burge then said that Hochman shipped her back to the alternate public defender's office, even though she'd received an exemplary performance review the day before Gascon filed the resentencing petition. So the other person in the office who was pro resentencing gets moved to another a public defender's office, which seems like a punishment, right? So they were just punished. They felt that the law said the Menendez brothers should be resentenced. These were two individuals who were just doing their jobs, says their attorney Justin Shigerian. A hearing on the Menendez brothers' resentencing is rescheduled for March 20th and 21st. Hochman has not made his position on their release public, but legal experts have said he cannot revoke Gascon's petition, likely leaving the brothers' fate in the hands of a judge, which would be the best scenario since Hochman doesn't seem to be pro resentencing or releasing them. Nearly 2 dozen of Erik and Lyle's relatives met with Hochman earlier this month and called for the brothers to be released. In a statement, those relatives said Monday that Theberge and Lunsford's claims only deepened their fears that Hochman was injecting politics into their loved one's case. So there you have it. Even the family thinks he's politicizing the Menendez brothers. Their commitment to the facts and the law was a source of hope for us, reaffirming our belief in the justice system's ability to evolve. The decision to remove these dedicated prosecutors from the case, however, underscored exactly what we feared, that political influences might overshadow justice. That was a statement from the family. The family has previously expressed concern about Hochman's decision to hire Kathy Caddy, a former prosecutor and victims' rights advocate who campaigned for him and opposed the brothers' release, to oversee the office's Bureau of Victim Services. So if you didn't know his position before, you do now. Hochman said that Caddy, who previously represented the only living Menendez relative that wants the brothers to remain imprisoned, is walled off from his review of the case. So this particular person, Kathy Katie or Caddy, however you say it, she is or is representing. Well, it says previously represented. She previously represented what's his name, Milton Anderson, or the uncle Anderson, who is opposing their sentencing. So that's like a huge conflict of interest, or conflict of interest. Yeah, I said it right. For some reason that didn't sound right. Anyways, that's because I'm thinking and talking at the same time. All right, so how dare I do two things at once? So this walled off, he's saying she's not going to be able to give input, I guess, on whether they're released or not. But we already know that he knows her position and he's probably all for it, all, on board with her position as well. So shortly after taking office, Hochman removed a number of Gascon's closest allies from leadership posts in the DA's office, according to transfer memorandums issued at the time. While elected officials have discretion over their leadership teams, nearly 20 prosecutors filed similar retaliation lawsuits against Gascon during his term. So this is only two, claiming that he demoted them for challenging his progressive policies. Whether that's true or not, I don't know. Lewin was among those suing. The veteran prosecutor who won a homicide conviction against notorious New York real estate scion Robert Durst claimed that he was banished from the Major Crimes Unit after becoming one of Gascon's most vocal critics and reassigned to a calendar deputy most similar to the one Lunsford is now. He settled his suit late last year. So Lewin had issues also? That's really oh, he was suing Gascon. Yeah, after becoming his one of his critics. If I'm in a position of power and there are people that work for me and clearly oppose me, I wouldn't want them in my office either. Like I totally get that, but proving retaliation is going to be hard, I think. But who knows? Maybe they think they have some proof for a case here. So the cases against Gascon involved whistleblower claims, with the plaintiffs contending that they were punished for pointing out legal flaws in his restorative justice policies. Only one in Gascon's policies was ever deemed illegal by a judge. The only one of the suits filed against Gascon that went to trial ended with a 1.5 billion verdict against the country. Several others are expected to be settled in the next few months. Shagarian said that his client's allegations also qualify as whistleblower claims because the state's resentencing law required them to seek a lesser punishment for the brothers, and Hochman retaliated against them for that decision. Lunsford and Theberge also accused Lewin of defaming them in social media posts where he claimed Theberge had no interest in justice, wanted to let criminals out of jail, and was dishonest in her filings with the court, according to the letter. Lunsford contended that by referring to him as a quisling, Lewin had likened him to a collaborator, according to the letter. The other N word that we can't say on YouTube. All right, so the word quisling has come to mean one who collaborates with an occupying force. It's derived from the last name of military officers. One was complicit or who was complicit in a takeover of the Norwegian government during World War II. Lewin, a political ally of Hochman, known for his at times combative personality both in the courtroom and online, have been an outspoken critic of the decision to resentence the brothers. So there you have it. Oh, there was a whole article. I thought there was more than that. I thought it went on to explain more about the like resentencing, but no. Okay, so that was the entire article of the Los Angeles Times titled Prosecutors Who Said Menendez Brothers Should Go Free Allege Retaliation by DA Hochman. Um, yeah, so what do you guys think about that? That's a little crazy, huh? That now we're finding out Hochman was like, get out of my DA's office. I'm transferring you to all these other places because I don't want you bothering me because you oppose my views, and I don't want the brothers out, apparently. Those are the signs I'm getting that Hochman doesn't want to let the brothers out. He also did not respond to the habeas corpus filing, which I believe the deadline for that might have been January 31st. I can't remember now. So many cases and dates are blurring together, but just recently was the deadline for the state to respond to the habeas corpus petition. And yet again, there's no response. And yet again, it's probably going to just be delayed, delayed, delayed because they have not responded. The state just won't respond. I don't understand what the problem is. Without their response, I don't think they can go forward unless the judge just is like, you know what, this is taking too long. But it would take like begging and pleading for the judge for them to tell the judge to just keep moving on without them. All right, so as a reminder, there's links below in the description before we get to the actual transcript here. And you have access to, first of all, you have access to this spreadsheet here, the 1996 Menendez Brothers Witness Testimony. I'm going to be updating it as we go along. So right now we're on week 2, and oh, I should update that right now. Yes and yes. We're going to read through Christine Nye and Michael Butkus's testimony, as well as finish up Detective Leslie Zoeller's testimony. So let's get right to it. The actual files, as you have the link to the October 1995 folder, we are going to be going on the October 16th. That's the date that we are on. And we are on page 236 for those of you following along. So we just went on a break And Miss Abramson is still questioning Detective Leslie Zoeller. So let's get started here. Please hit that like button if you don't mind. I often forget to say that at the beginning. All right, so the court says something you want to discuss. Miss Abramson says, yeah, I thought we would tell the court that we had done the witness list. Mr. Gessler says, yes, we filed the witness list, our proposed witness list, the best we can at this time, Your Honor, with estimates that are obviously, Miss Abramson says, loose. Mr. Gessler says, somewhat in the dark. And we checked with the district attorney's office. The week that they have on their list for November 6th really should be October 30th because that week was totally left blank on their list. And so I guess their list gets moved up a week because they said they had a 3-week estimate for it. Ms. Abramson says, in addition, Ms. Nahara has informed me that the name of 2 of the witnesses were inadvertently omitted from their list, and that's Sheriff Deputies Dula and Guthrie. Let's highlight that. Let me make sure my highlighter's selected there. All right, so Ms. Nahara says, right. The court says, okay, and anything else? All right. If I could ask you to move the podium back and to your right, I don't want the jurors to be able to look at what you have on the podium. Miss Abramson says, all that was here before was my little handwritten notes, which would be hard to read. The court says, whatever it is, whether it's you or the other lawyers, I don't want them to inadvertently have an opportunity to see what's there. She says, okay. Or he says, okay, let's get the jury out. Court says, okay, everybody's back. You may resume your cross-examination. Ms. Amerson says, thank you, Your Honor. Detective Zoeller, we were talking about that time. What was the date again in March of 1990 when you were at the bank? He says, March 8th. And at some point, did you or Mr. Mogul and the Oziels leave the bank and go back to the Oziel residence? Yes, we did. And at that residence, did you take into your possession for any period of time the tape or a tape similar to the tape that was played in court today? Not today, played in court 2 days ago. The one with the voices on it of Lyle and Erik Menendez. I didn't take it in my possession, but I did see the tape. And did you listen to a portion of that tape on March the 8th, 1990? Yes. And do you recall that when you listened to a portion of the tape on that date, you heard 3 voices on that tape? Yes. And at that time, as the March 8th, 1990, were you already familiar with the voices of Erik and Lyle Menendez, having talked to them before? Somewhat, yes, he says, somewhat. And you heard voices that sounded like them? Yes. And you also heard the voice of a third person? That's correct. And did that third person's voice on that tape sound like the man who identified himself to you as Jerome Oziel, the man who lived at the house where you were living or listening to the tape? Yes. And was it your understanding that under a search conducted by a special master that you, in fact, as the police officer, had a right to listen to the tape at the time? Yes. Have you subsequently found out that that's not technically true? Objection irrelevant, says Mr. Khan. The court says sustained. Ms. Abramson says, did you ever, either on that date, March 8th, 1990, or any day subsequent to that, obtain possession of any tape recorder that was ostensibly used to create the tape of those 3 voices that we heard in court? No. Is it true that you have absolutely no personal knowledge of when the tape was made? That's correct. Is it true that you have absolutely no personal knowledge of where that tape was made? That's correct. Is it true that you have absolutely no personal knowledge of what conversation, if any, preceded if any, proceeded at that point when when the tape recorder was on? Correct. Neither you nor anyone to your knowledge, altered that tape. Is that correct? That's correct. And does that tape, in its physical configuration, lack what's known as a leadership strip? If there was one, yes, it does. There's no leader on the tape as it appears here as an item of evidence? Correct. And it does just start with people talking, correct? Yes. And it did on March 8th just start with people talking. Yes. March 8th, 1990? Correct. And to your knowledge, did the tape go from the Oziel household into the possession of Mr. Mogul and ultimately delivered to the Superior Court in Santa Monica? Yes. And to your knowledge, was that tape kept part of the possession of the Superior Court from that day to this? Yes. Now, is it also true that you have no personal knowledge whatsoever of whether or not other people were present when that tape was made? Even though there are no other voices but the three voices on it, so you don't know if anybody else was present, even though there are no other voices. He says that's correct. And you have no idea whatsoever whether or not during the making of that tape, the persons whose voices you hear were reading from any documents or scripts or writings. No way to tell you that. And you have no way of knowing whether or not any of the participants in the making of that tape were under the influence of any intoxicants of any kind. That's correct. And you had no personal contact whatsoever with Jerome Oziel before that day. No, I had not. And in fact, the week before that you never even heard of the man? Is that a fair statement? No. Had you heard of him the week before? The week before March 8th? I take that back. You only heard about him in September when Erik Menendez mentioned his name to you. That's correct. Between September 17th and this March 8th, did you in fact contact Jerome Oziel? No, I did not. So Erik even mentioned his doctor, but never, there was no follow-up from law enforcement on that. Did you ever talk to him between those dates about Erik Menendez? No. Did you ever try to obtain any records from him? No. And is it also true that you have absolutely no information whatsoever about how long the three people whose voices appear on that tape were together before that tape was made? No. And you have no information about how long they may have stayed together after the tape was made? That's correct. And you have no information, for example, about whether all three people during the making of that video or tape, during the making of that tape, could hear everything that each other were saying, other than what I assume on the tape by different responses, other than what's in the responses. If there's an area where no one seems to be picking up on what someone else said, you can't say whether they even heard it. Correct. And when was the next time after March 8th, 1990, that you ever listened to, let me strike that, on March 8th, 1990, you didn't listen to the entire tape, did you? No, I did not. Just a little bit? Correct. And after that date, when was the next time that you actually heard any of the voices on that tape? When it was released to the prosecution in the last trial. So he never even heard it until trial in its entirety. You're a cop. You're the lead. You should have listened to it all. And you mean when the prosecution got a copy of it? Correct. And were you in court during the last trial when that tape was played by the defense for the jury? Yes. And was that the first time the tape had been played in court? Yes. I have nothing further, Your Honor. Thank you. Any redirect? Says the court. Mr. Khan says yes. Miss Abramson says, let me move out of your way here. Redirect examination begins. Mr. Khan, You indicated that sometime in the morning of Monday, August the 21st, you returned to the crime scene over the defendants. Is that correct? And Detective Zoeller says that's correct. So you indicated that prior to the time that the crime scene was turned over to the defendants, there was what is sometimes referred to as the yellow tape, the yellow tape outside the Menendez residence. Is that correct? That's correct. How do you know? Do you have any personal knowledge as to how long that yellow police tape remained up? No, I do not. And why is that? Because I left. I believe that the tape was still there. At the time of our investigation, the tape had actually been blocking the street and not in front of the house. Okay, and what time did you leave that morning? Between 8:30 and 9:30 in the morning. You indicated that you believe that the coffee table may have been moved by the coroner's investigators at the time that the bodies were being removed from the crime scene. Is that correct? That's correct. Prior to that time, do you have any information or any reason to believe that the coffee table was moved during any part of the investigation? It was not. So the photographs of the position of the coffee table that have the bodies of Kitty and Jose Menendez depicted in them would reflect the way the coffee table remained from the time that you arrived until the coroner's office moved the bodies. Is that correct? That's correct. You indicated that certain modifications to the diagrams that had been marked here in court, that is diagram number 2, which is the exterior of the home, diagram number 5, which is the second floor of the Menendez home, diagram number 6, which is the first floor of the Menendez home, and diagram number 24, which is the Menendez den. Other than the modifications or the possible changes that you feel might be necessary for those diagrams to make them accurate, are those 4 diagrams accurate depictions of the Menendez home? To the best of my knowledge, yes. Directing you specifically to diagram number 5, which is the second floor of the Menendez home, you indicated that on the right-hand side, the upper right-hand side, there was outside the master bedroom what appeared on the original blueprints to be a circular stairway on the outside of that residence. Is that correct? That's correct. And in an early draft of that diagram, that has been marked as diagram number 5. Do you see such a circular stairway? Yes. And did you ask that that circular stairway be removed because it was never actually built that way? That's correct. And was that removed at your request and instruction? Yes. You were shown a photo. I want to know more about that. Why they took a whole staircase? Why? You were shown a photograph by defense counsel of some animal feces that appears on the floor of one of the bedrooms. Is that correct? That's correct. It's not up here. Okay, but you indicated in your testimony that there are 2 dogs inside the residence. Is that correct? That's correct. Do those dogs remain inside the residence for the entire time that you were there, in their home conducting your investigation? Yes. And that would be from approximately, I believe you said 1 in the morning until 8:30? Correct. Did anyone walk the dogs? No. District attorneys are conferring. Mr. Khan says, I'd like to show you the exhibit that has been marked as 17 at this proceeding. You described this as being the French doors and the window that are on the south side of the den. Is that correct? That's correct. It appears that the shutters of the windows are open so that you can look inside and you can see the interior of the room. Is that correct? That's correct. And is that the way the shutters were at the time that you arrived? Yes. And to your knowledge, were those shutters open at the time the first patrol officers arrived at the scene? To my knowledge, yes. You indicated that when you were sometime after your initial investigation, you returned to the home in December. I believe you said with a search warrant. Is that correct? That's correct. And at that time, you found some paperwork concerning a Mr. Whitkin. Is that correct? That's correct. I would like to, at this time, I would like to mark, this is Mr. Khan speaking. I don't know why it's in the answer. Mr. Khan says, I would like to, at this time, mark an exhibit which has previously been marked as 64 for in the past trial. It appears to be a receipt. I'd like to mark it as 81 for identification. The court says 80. Mr. Khan repeats 80. Ms. Abramson says the same. Mr. Khan says, I have 80 for the sprint records. Court says that's 79. Mr. Khan says, showing you what I have just marked as 80 for identification, do you recognize this document that I'm showing you? Yes, I do. Can you tell us what that is? It's a receipt from Leviathan Development, and it says, Ms. Abramson says, I'm going to object, Your Honor, as hearsay. The court sustains it as to what it says, just to indicate whether or not you've seen it before. The witness says that this is an item that I collected on the television on the 5th of December that I recovered as evidence. Mr. Khan says, and after you recovered that item, did you contact someone? Yes. Who did you contact? Ms. Abramson says, Your Honor, I'm going to object. This is beyond the scope. The court says overruled. And the witness says Howard Whitkin. Mr. Khan says, and is that a name that appears in that document? Yes, it is. You indicated that there was a statement made by the coroner's office concerning the possibility of organized crime being involved in these homicides. Is that correct? That's correct. And I believe that you indicated in response to a question by counsel that you did not have information regarding an organized crime connection. Is that correct? Correct. Did your office pursue an investigation into this possible organized crime connection? Yes. And what was the reason for that? Ms. Abramson says, Your Honor, I think this calls for hearsay. The court says the reason why, overruled. The witness says the reason why was to determine whether, in fact, there's been any word or evidence to show that the organized crime aspect was or was not involved. Mr. Khan says, and what investigation did your office do in that regard? We had two investigators go to the New York, New Jersey area to contact the FBI, organized crime, details back to the East Coast. And who were those two investigators? Detective Sargent and Edmonds. Oh, sorry, Detective Sergeant Tom Edmonds and Detective Plog. He doesn't have a first name. He just goes by Plog. I would like to show you the diagram of the exterior at the time that they had been marked previously as People's 2 for identification. Now, you indicated that in the course of your investigation, you observed what appeared to be holes through the French doors on the south side of the den. Is that correct? That's correct. And what would be here and that would be here. Is that correct? So we must be showing him a picture. He says that's correct. And you also indicated that you observed what appeared to be pellet defects to a tree on the south of the den. And that would be the tree here. Is that correct? That's correct. When you indicated in response to counsel's question that you determined then that a shot was fired from north to south on the axis here, Miss Abramson says, well, I'm going to object to counsel leading the witness on what the axis was, since he never described it in detail. The court says, all right, there was some testimony that the witness determined that the general direction of fire was north to south, for the most part, is what he said. Miss Abramson says, right. Mr. Khan says, do you recall testifying that there was a north to south direction of fire? Yes. And did you also determine, as part of that conclusion, as to whether the shot was fired directly north to south or whether it was also easterly or westerly? It was slight easterly direction. So it would have been this way. Is that correct? That's correct. Mr. Kant says, Your Honor, I hold in my hands an evidence envelope which was previously marked as 17 in the first trial. May it now be marked as 81? The court says, yes, the envelope and its contents. Mr. Khan says, showing you what I've just marked as 81 for identification, can you tell me if you recognize what that envelope is? Ms. Abramson says, Your Honor, just for the record, technically speaking, I believe this is beyond the scope of my examination, but if the court says, well, it is not. The general area was covered. Objection overruled. He just cuts her off. The witness says, It's an envelope containing numerous pellets, shotgun wads that I obtained from the coroner's office. Then Mr. Khan says, Can you tell us how it was that you obtained these items that are all contained within the envelope that has now been marked as 81 for identification? Zoeller says, At the time of the autopsy of Mr. and Mrs. Menendez, these items were taken as evidence from the bodies of Jose and Kitty Menendez. The coroner's office the coroner's office then booked them into evidence in their manila little packets and stored them until I picked them up on November 2nd of 1989, at which time I booked them as our evidence. Mr. Khan says, All right, now counsel asked you about all of the wadding that you recovered from the crime scene. Did you also recover certain pieces of wadding as well as some pellets from the coroner's office? Yes. And did you receive from the coroner's office a total number? Ms. Abramson says, Your Honor, if counsel's going to suggest a number, I would object that it's leading. Court says sustained. Mr. Khan says, Can you tell us how many envelopes you received together as part of one separate package? Ms. Abramson says, If I may approach, Your Honor, the court says yes. The witness then says, I don't understand what you mean by how many items in one separate package. Mr. Khan says, In other words, how these items are grouped here. Do you see them numbered as part of two separate groups of packages? Yes. And can you tell us why they were numbered as two separate groups of packages? One is from the autopsy of Mary Louise Menendez, and the other one is of Jose Menendez. Okay. I would like to direct your attention right to the one concerning Mary Louise Menendez, and I believe that is the one that you're holding in your hand now. Can you tell us how many separate envelopes you received as part of that group of packages or group of envelopes? He says they're all mixed up, so if I could, what I am holding, there are 4 separate envelopes for Mary Louise Menendez, 4 additional. So there are 8 envelopes for Mary Louise Menendez. Okay, and if you can just tell us what those 8 envelopes consist of, going through them one by one. On the first one, there's no designation by the police department, but there is a description of where it came from, and it's 2 pellets. Would you like me to say where they came from? Ms. Abramson says, Your Honor, I'm going to object to him reading those envelopes. The court sustains that. Objection sustained. Were you present? The court asks, Were you present when each of these items was removed from the bodies of the decedents? The witness says, Yes, I was. Mr. Khan continues, So the first envelope that you referred to as contains 2 pellets. Without telling us where they were removed from, at this time I would only ask you to describe the objects that are contained in the separate envelopes. The court says, rather than doing that, since I assume there's someone else who is going to describe them in more detail, if there is, just generally, you can describe what is in all of these rather than going through each one. Mr. Khan says, All right, can you tell us what collectively is contained within these 2 sets of envelopes? Collectively, they are anywhere from buckshot, birdshot, and wadding. And we've gone through this. Buckshot is the bigger pellets. Birdshot would be tinier pellets, more pellets inside the shell. And then the wadding is like a material, sometimes fabric, sometimes plastic, that goes in between where the gunpowder is and the buckshot or birdshot inside the pellet. So we've explained that. We've looked at pictures. If you want to look again, I can pull it up. Give me one sec. So here I have on the screen for you another the picture of the shell, the bullet shell or shotgun shell, and you can see the primer which is what is engaged within the shell that engages the gunpowder, which is separated by the wadding, and then you've got the projectiles, which are, in this case, birdshot or buckshot. There's other kinds of pellet sizes, but I don't know all of them. The only ones that I've ever heard of as referred to are buckshot and birdshot. So that's my very little knowledge of what it is. So, what is he? Next question is from Mr. Khan. Okay, and were all of these items recovered from the body or the clothing of the victims in this case? Yes. All right, you may return these to the envelope that has been marked as 81 for identification. Now, in regard to the tape recording that we listened to here to the defendants and Dr. Oziel, is it your opinion that the voices on the tape sound like Erik and Lyle Menendez, or is it your opinion that it is Erik and Lyle Menendez speaking on the tape? Ms. Abramson objects, and she says, Your Honor, either way, it could only be his opinion. The court says, well, it's obviously his opinion, but you can answer the question. The witness says, I believe it is Erik and Lyle Menendez. Mr. Khan says, and you are also familiar with the voice of Dr. Oziel? Yes. And since the time, I believe counsel pointed out that you didn't have that much contact with Dr. Oziel prior to the time you recovered the recordings. Is that correct? Correct. Since the time of that recovery, how many opportunities did you have to speak to Dr. Oziel? Numerous. And are you also satisfied that the voice of the tape is the voice in of Dr. Oziel? Yes. So you indicated that there is no leader strip on the tape recording. Can you tell us what you mean by a leader strip? Yeah, I'm glad. I didn't know what that was either. A leader strip is where they identify the date, time, and possibly even the speakers on the tape. Oh, I just didn't know that's what it was called. Um, but yeah, introductions, um, protocol that you should probably record the date and time and other information like my name, this is the voice of so and so, and I have in the room with me Eric and Lyle. That's how it should have been. But okay, so a leadership is where they identify all that stuff. Okay, so by you're not referring to anything that was physically missing from the tape. You're saying there's no formal introduction on the tape. Is that correct? Correct. Thank you. I have no further questions, Your Honor. All right, recross. Now we are at recross examination. Leslie is back at it. Detective Zoeller, perhaps I misled you. Let's see, do we have a tape here, a blank tape? When I was referring to a leader, you're familiar with the fact that audio tapes, if you turn them on, they don't start making noise right away. There's like a blank piece? Correct. Usually it's clear, a plastic portion. So there's a clear piece of plastic before you get to the brown tapey stuff. Correct. That's what I meant by the tape leader. Okay, so there's two different meanings, I guess, or maybe he just thought that's what she meant. I don't know. So is that part? It's that part that you can't record on, that spool, the tape. Okay. I think that jury heard there's no introduction, there's none of that, but they haven't seen the tape. I'm talking about physically, is it your recollection there's no little piece of leader on the tape? I didn't look at the tape. Well, let me show it to you. Hopefully, it's been rewound. Court says 59, that's the number of the exhibit, excuse me, 59. It has to be rewound, Your Honor, to have an evidentiary value at this point. I'll hold off on that. And next question. What I would ask Detective Zoeller is if you have an opportunity to have it rewound here and take a look at it, and I'll ask you that question again later on the trial, later on in the trial. Okay? Okay. Thank you. Were these the first autopsies you ever attended? No. How many have you attended before this? Roughly? Or how many have you attended before this roughly? 25. And had you ever attended an autopsy conducted by Dr. Golden before? I believe so, yes. And during the course of the autopsy, does Dr. Golden make notes out loud or make notes in writing as he goes along? He makes notes in writing and then he discusses what he sees with those in attendance. Okay. So as he's going through it, he's saying what he's seeing and he's pointing things out to you? Yes. Do you see any reason to correct him or to doubt him during the course of these autopsies? We deferred on some of these shots, but no, I didn't doubt. What do you mean by deferred on shots? As far as his determination if they were one shot or two shots. Okay. You had certain opinions about whether wounds were caused by one shot or two shots. Correct. Even though you have no expertise in ballistics? Correct. And you have no expertise in the subcategory called wound ballistics. Correct. Now, have you reviewed the addendums to the autopsy report that Dr. Golden came out with, one in 92 and one this year? No. So, do you know if he has perhaps aligned himself with your interpretation or further distanced his interpretation from yours concerning how many shots caused the wounds? Interesting. So, did the medical examiner change their opinion about the number of shots that occurred? He says no, but she says you had certain impressions based on your layman's view of the bodies at the scene. Correct. And then Dr. Golden explained to you why perhaps you were wrong. He tried to, yes. And do you know who Dr. Sherry is with the coroner's office? Yes. Have you attended autopsies that Dr. Sherry has conducted? Yes. Are you aware that Dr. Sherry was reviewed or has reviewed all of Dr. Golden's work on these autopsies? Objection, irrelevant, sustained. Ms. Abramson says, did you ever talk to Dr. Sherry about your views versus Dr. Golden's views? No. So you thought there were more shots than Dr. Golden thought. Isn't that true? Yes. Okay. Well, why is that? Why is this the first time I'm hearing this? I don't recall this in the first trial either, but you know what? We watched that so long ago that I can't remember. But maybe I should rewatch it. But I don't remember this coming out. Correct me if I am wrong here. All right, question. Are you aware of the opinion of Mr. Roger McCarthy concerning how many shots were fired? Mr. Khan says, objection irrelevant, sustained. Ms. Abramson says, how many shots did you think had been fired based on your layman's perspective? The court says, time frame, are you talking about at the time of the autopsy? Yes, Your Honor. Witness says, I thought there was 13 to 15 total shots. That is what he originally testified to. I do recall that, so that tracks for me, even though I don't remember the other stuff, but I do remember that was kind of their theory that there were 13 to 15 shots, but there weren't even that many bullets that were used, so it didn't make sense to me how they got there. But as Abramson says, and Dr. Golden indicated he thought there were fewer. Correct. Are you familiar? Well, were you present in court during the testimony in the last trial of Sheriff Deputy Dwight Van Horn? Yes. Do you disagree with his conclusion about how many objection calls for hearsay? Ms. Abrams says, I'm not stating what it is. And then she asks her question, are you familiar with, without stating what Deputy Van Horn's conclusion is as to how many shots the ballistics evidence alone indicates occurred? The court says, you can say yes or no. The witness says, yes, but I don't remember the number. Ms. Abramson says, do you remember whether or not that number seemed to you to be an accurate evaluation of the ballistics evidence, the number of wads and shot cups and that? I don't recall what number he said. Now, you were asked by Mr. Khan whether you had opportunities to speak to Dr. Oziel after March 8th, correct? Correct. Did you, in fact, sit in this courtroom and listen to him testify for 6 days during the last trial? Yes. And you certainly had an opportunity to hear his voice then. That's correct. After the time that you picked up the evidence that's contained now in, let me make sure I get it right, 17. Not anymore. It isn't. What did we surrender this? Mr. Khan, court says, what are you talking about? The witness says, the package that used to be 17. The court says 81. Miss Abramson says, thank you, Your Honor. I'm going to write 81 on there. You said that you collected this package containing the ballistics evidence that was recovered by the coroner's office on November 2nd, 1989. Yes. And was that evidence, along with the entire package that now consists of 48, at some point sent to the sheriff's department for their evaluation? Yes. And to your knowledge, at some point did Mr. Charles Morton, a criminalist working on behalf of the defense, examine both the envelope called 48 and the envelope 80 at the Beverly Hills Police Department? No. Was it sent to his laboratory in Oakland? I took it to his laboratory in Oakland. Both packages? Correct. Do you recall a time when myself and a former attorney for Lyle Menendez, a Mr. Michael Burt, looked at all those items of evidence, those which are contained in 80 and those which are contained in 48 at the Beverly Hills Police Department? I remember you doing that. I don't remember Mr. Burt being there. Made an impression on you that day. Okay. And in fact, are there initials on the packages that are contained in both 80 and 48 reflecting Mr. Morton's examination? Yes. And are there initials reflecting Deputy Van Horn's examination? Yes. Are there initials indicating that Ron Linhart looked at it? Possibly. Are there any initials indicating that Roger McCarthy looked at it? Not that I see. Nothing further. Court says further examination, redirect examination by Mr. Khan. You indicated that it was your opinion that between 13 to 14 shots were fired. That's correct. And when you say shots fired, you're not talking about separate injuries to the victims. You're talking about that 15 shotgun shells were fired in that room. Correct. And what is your basis for that opinion? The wounds themselves of the victims, plus I counted each hole in the French doors as 2 shots. But like what? Where's your opinion coming from that? Mr. Khan says nothing further. Ms. Aronson says, let me just see if I can understand what you're saying. You assumed that neither of the shots that went through the French doors had hit either of the victims before going out that way? Correct. And you also counted each and every wound on each of the 2 victims as totally independent shots. For the most part, yes. So that if there were 10 areas of wound, for example, on Ms. Menendez, you assumed 10 shots were fired. Are you talking about individual pellets? No, individual areas of wound. Yes. I have nothing further. Thank you. The court says anything else? Mr. Khan says nothing further, Your Honor. Thank you. You may step down. Your next witness. All right, so we are now with Christine Nye. She's a dispatcher from 911. So people are calling Christine Nye to the stand. She was sworn in. The clerk says, raise your hand, blah, blah, blah. She's sworn in. She says her name. All right, you may examine the witness. Miss Nahara or Nahara. Thank you, Your Honor. Direct examination begins. Ms. Nye, was it your occupation, or what is your, sorry, what is your occupation? First of all, the reason I screwed that up was because I was thinking and talking or reading at the same time. Oh, you guys definitely voted to hear this. So that's why I'm reading through Ms. Nye's testimony. She's the 911 dispatcher. You guys voted for this. You also voted, where is it? So you guys also voted for Michael Butkus. It was a lot more lukewarm. It was more like 60-40, but I will read through his. I don't think it's that long. So we'll get through some of his, and then we'll also read through I got to do a quiz for Avril Crom to see, or a poll to see if you guys want to listen to hers. And also Sergeant Thomas Edmonds, we're going to do a poll for him. But the other ones here that you see a yes for, we're going to read through. So those will be the upcoming polls. Look for those and get your votes in. All right. That's all I wanted to say about that. All right, so direct examination by Miss Nahara. Ms. Nye, what is your occupation? I'm a dispatcher for the Beverly Hills Police Department. What was your occupation on August 20th, 1989? The same. And back on that date, August 20th of 1989, how long had you been with the Beverly Hills Police Department as a dispatcher? A little over 2 years. And what were your duties at that time? My duties as a dispatcher were to take incoming calls to the police department, routine as well as emergency, including 911s, and to dispatch them to the police officers. And on the evening of August 20th, 1989, do you recall what time you came on duty? I'm not really certain. I think it was 6 p.m. Are you certain it was before 10 p.m.? Yes. And on that day, August 20th, calling your attention back to August 20th of 1989, did you receive a call via the 911 operations? Yes. And can you describe what it was you first heard? A lot of screaming and crying in the background. And at some point, were you alone or were you with someone? At what time, or at that time, I was alone just for a few minutes. My partner had left the room for just a few minutes, so I was alone. And at some time during this conversation, did your partner come back into the room? Yes. And who was your partner that day? Nick Tatone. And how far into this conversation did your partner come into the room? Probably about 30 seconds, maybe a little less than that. Now, could you describe what you did when you first received this call? I was also dispatching, so I three beeped, which means you hit a tone that's an emergency call, and I sent a unit immediately to a possible shooting at that address. And at some point after your partner came in, what happened? He took over the call, and I just coordinated the unit's response. And were you the present throughout the call? Yes. From the location? Yes. And at some point did the conversation end? Yes. And what happened after the conversation ended? We got the units rolling. We rolled paramedics and then I believe they asked us to get them back on the line. Did someone get the people who phoned 911 back on the line? Yes, my partner Nick did. And about how much time elapsed between the first 911 call into the second call back at the home? That's weird. Why did they call them back? It was 3 to 4 minutes, something in that area. And do you recall, as you sit there, where the location was that you received the 911 call? 722 North Elm. I'm showing you what's been marked previously as an exhibit in this case, Exhibit 78. I approach the witness, Your Honor. The court says yes, or may I approach the witness, Your Honor? Court says yes. Ms. Nahara says, showing you Exhibit 78, do you recognize this document? And Christine Nye says, yes, I believe I saw it last time around. Did you testify in this case prior to today? Yes. What was in the last trial? What was that? Was that in the last trial? Yes. And did you see that document at the last trial? I believe I did. And is that a some kind of a record of the dispatch calls that were made into 911 and out of 911? This would be a court record. It's not the record that we keep, but yes, it's a record. Does it reflect the time accurately that you received the 911 call? Yes, uh-huh. And was that at 11:47 in the evening? Right, 23:47, which is 11:47 military time. And the second call that was made back to 722 Elm, is that also reflected in that document? 23:49, I believe, yes. And was it a few minutes from the first call? It was approximately 2 minutes after the first call, if that's what I'm looking at. Is there another call at, oh, I'm sorry, I don't know what this one is, but it on the callback it states 23:51. That's coming from the witness, the Ms. What's her face? Oh my God, I totally am blanking on the attorney's names. Not to worry, I'm gonna go back to my thing here. Because if you guys are ever wondering who is being represented or who's representing what, we've got for the people of California, we've got Gil Garcetti, who we still have yet to hear from, and Carol Nahara and David Kahn. I believe he's just the DA. I don't know if he actually is presiding this case, but he's listed. And then for Lyle Menendez, we have a Michael Judge, who we also have yet to hear from, a Charles Towery, or a Charles Gussler, and a Terry Towery. For Menendez, Erik Menendez, we've got Leslie Abramson returning and Barry Levin, who is new. Stanley Weisberg returning as the presiding judge. So, and I came on here just to say Carol Nahara is who is, whoops, doing the questioning right now. All right, so this is a few minutes later, right? And at the first trial, did you have an opportunity to listen to the 911 tape? Yes, I did. And did that tape reflect the conversations that you were a party to on August 20th, 1989? Yes, it did. Your Honor, I have a tape recording which was previously been marked as Exhibit 1. We'd like to mark it. Court says 82. Ms. Nahara says 82. Thank you. Okay, at the last trial, did you also have an opportunity to review a transcript of the conversations that you were a party to? I believe so. And have you recently also had a chance to review a transcript of the conversation that you were a party to? Very, very briefly. Ms. Nahara says, Your Honor, I have another exhibit which I'd like marked as People's 83. Ms. Abramson says, is that previously 130 or something like that? Ms. Nahara says, this could be, yes, the previous exhibit, Your Honor. Court says, and it was what is the first trial? It was what in the first trial? She says, I believe it was 149. Ms. Abramson says she agrees. Mr. Khan says 5. Ms. Nahara says, Your Honor, that was previously marked 135. Court says, all right, 135. It will be 83 here, but 135 in the first proceeding. Ms. Nahara says, may I approach the witness? The court says, yes. And showing you what has now been marked as 135 could, if she means 83, would you take a look at the document and tell me if you recognize it? Yes, I do. And can you tell us the jury, or can you tell the jury what that document is? It's the transcripts of the 911 phone call. Now, are there several voices on the tape that has just been marked as 78, previously 1, which is the conversation that you were a party to on August 20th, 1989? You mean 82, counsel, says Ms. Abramson, previously 82. The court says, what was the question without the interruptions, counsel? She says, I'm sorry, I'm trying to get the record straight. Because you're not paying attention, Judge Weisberg. The court says there's ways to do that. Let's have the question repeated, please. Miss Nahara says, thank you, Your Honor. Do you see how rude he is to her? Oy, oy, oy. Okay, Ms. Nahara says, thank you, Your Honor. Did you have an opportunity when you listened to the tape that was played in the first trial to listen to the voices? That wasn't her question at all. Yes. Did you recognize the voices on the tape? Yes. And who were the voices on the tape? Mr. Levin says, objection would call for speculation, no foundation. The court sustains it. And Ms. Nahara says, is your voice on the tape? Yes, there is. Are there any other voices on the tape? My partner, Nick Tatone, and the caller. And is there more than one caller on the tape? Mr. Levin says, objection calls for speculation, no foundation. The court says, were you able to distinguish the voices if there was more than one voice of the callers? The witness says, well, one was talking to us, the other one was in the background, so I never talked to the second party. The court says, but you could distinguish two voices? Yes. Ms. Nahara says, and Your Honor, at this time, I have a tape recording and a transcript. I have had an opportunity to give the transcript to the defense. They saw it last week, and I'd like an opportunity to have the deputies give it to the jury now. Court says, all right, the transcript is 83, Exhibit 83. Bailiff says, do you have one, Judge? Court says, when you give it to me, I will. So, is that funny, or is he just being a dick to the bailiff, too? I don't know. Ms. Nahara says, and Your Honor, we'd stipulate that the court reporter does not have to take down the transcript. So the court says, okay, join in that. Ms. Levine says, join. So they don't take down the transcript. Um, I know they played it in the first trial, and it's very difficult to listen to. You can just hear screaming and Lyle going, "My dad! Someone killed my dad!" And it's real like it's hard to listen to. So we're not gonna play it again, but just to remind you of what it was like. All right. So Ms. Nahara says, Ms. Nye, do you recall that the tape you listened to in the first that do you so they listened to the tape in court. So now Ms. Harris is saying, Ms. Nye, do you recall that as the tape that you listened to in the first trial? She says, yes, it is. Is that an accurate rendition of the conversations that you were involved in? Yes, it is. Now, you were on duty at 10 that night, is that correct? Yes. Now, at that time, as the dispatcher for Beverly Hills, would you have received all of the incoming calls involving any 911 emergencies? Either I or my partner at the time would have, yes. And on that night prior to 10, did you receive any phone calls of shots fired in the area? No, we did not. If such a phone call had come in, would it have been routed to you? Yes, it would. And at 10, did you receive any phone calls of shots fired in the area? No, we did not. Between 10 and the time that you received the 911 call from Elm Street, did you receive any calls of shots fired in the neighborhood? No, we did not. The next person up to testify after we're going to get through Christine Nye and Michael Butkus in today's episode. So the next person is Avril Crom. She's the neighbor. She heard the gunshots. Do we want to hear her testimony? I don't think it's very long, so I'm willing to read I mean, I'm enjoying reading this. It's actually going a lot easier and faster than I thought. And by the way, I did like an 8-hour video altogether combined going through the timeline complaint from Justin Baldoni regarding Blake Lively and Ryan Reynolds. And so I did a lot of talking and a lot of sitting that on, those days that I was recording. So I realized I can do a lot more recording as long as I turn my camera off and lay down. So at some point, I'm probably going to do that during this video. And then I can give you like a longer video where we get like close to a day's worth of testimony in. So we'll see how that goes, getting these longer ones in. I think it should work. And I don't mind doing it. So, well, I just wanted to, sorry for the interruption again, but I just wanted to remind you that You guys have the option to vote, and that's who you would be voting on next would be Avril Crom. She is the neighbor who heard the gunshots, but nobody called, as we're seeing from this testimony. And did you receive any information from any police officers just via regular dispatch of shots fired in the area? No. Was there any information that came into Beverly Hills routed through you of shots fired in the area between 10 and 11:47? No, there wasn't. If there had been such information, would you have gone through it? Would it have gone through you? Sorry. Would it have gone through you? I swear to God, I'm dyslexic. I've never had this problem before, but somehow now my brain just scrambles all the words on the page and then like I see them and I can't get them out in the right order sometimes. So apologies. All right, so Ms. Nahara continues on saying, thank you. I have nothing further at this time. Now we are going into a brief cross-examination by Mr. Levin. He says, good afternoon. She says, hi. He says, you stated that you were the only dispatcher that evening. No, there was a partner I had with me. He stepped out of the room to use the restroom at the time. And that's Mr. Titone? Nick Titone, yes. Now you're looking at that transcript in front of you. I notice there's a U for unidentified person designated to some conversations on the tape. Now, having just heard the tape, do you know who that U is? Yes, that's Nick Titone. Do you know why now you knew who Nick was all the time, did you not? Yes. Do you know why he wasn't identified in this transcript? No. Did you ever inform the prosecution that you knew who that person was? Yes. All right. Now, you indicated, so the prosecution is providing a transcript with an unknown name, but they know who it is, and they could have easily asked Christine Nye, who was that person in the background? But for some reason, they're not doing that. All right, you indicated that you had been a dispatcher for 2 years before this incident. Had you received other calls like similar to this before, calls where there were shootings? No. This was the first time you had ever taken a shooting call? At the time, yes. At the time of my career, this was the first time. Would you agree that the person or the call that you had taken was a highly emotional call? Yes, I would. Objection calls for speculation. The court says, well, it's ambiguous as to what you meant. So, objection sustained. The answer's stricken. Mr. Levine, or Mr. Levine continues his questioning. Did you immediately, upon receiving this call, make some notification? In other words, when the call first came in, did you then notice or notify the units that were in the field? Yes, I did. Now, how were you able to do that as the call was coming in? I'm sitting at a console that has a phone right here and the radio right here. It's all in one. So I had my hand on the phone, and I used the finger to go ahead and put out the call to the officers. Okay, and you indicated your first action was to beep 3 times? Yes. And who was that beep going out to? To the units in the field. So they hear an audible 3 beep indicating it's a hot call that's getting ready to come out so they can pay special attention and be alert? Right. The call back that you received, how long did it take before you received the call back? We didn't receive a call back, we called back. Did you receive any indication that an officer was responding to your 911 call? Oh, yes, through the radio. And how long did that take? A second. Would you say it was only a couple of seconds before the first responder arrived at the scene? Yes. Mr. Levin, thank you. I have nothing further. Ms. Abramson says, could I have a moment? And the attorneys talk. Mr. Levin says nothing further. The court says, after questioning on behalf of, or any questioning on behalf of Lyle Menendez, No, Your Honor. So far, I'm not impressed with the representation that Lyle has. They aren't doing a whole lot of advocating for Lyle. I'll just say that. The court says, okay, thank you. You can, unless there's redirect. Ms. Nahara says, no redirect, Your Honor. The court says, you can step down. You're excused. All right. We're moving on to Michael Butkus. A very unfortunate name. All right, so Michael Butkus was called to the stand by the people, was sworn, and testified as follows. And we'll skip that. All right, so direct examination by Ms. Nahara. Sir, what's your occupation? Police officer for the city of Beverly Hills. And were you so employed on August 20th of 1989? Yes, I was. And in what was your assignment on that date? I was working patrol. And what were your duties? Working in a black and white police car in uniform with a partner. And that night, who was your partner? Officer Zanaki. And as of December 20th, 1989, how long had you been a police officer? I had been a police officer for 4 years. And were you called to testify previously in this matter? Yes, I was. And did you testify in a trial on July 20th of 1993? Ms. Abramson says, Your Honor, at this point I'm going to object. It's relevant when he testified. The court overrules it. The witness says yes. I don't know why you would need to object to that, but whatever. All right. Ms. Nahara says, now, on that date, going back to August 20th of 1989, were you at some time that evening dispatched to 722 North Elm Street? Yes, I was. Was this in the city of Beverly Hills? Yes. And was this at approximately 11:47 in the evening? Yes, it was. And can you tell us why it was that you were dispatched to that location? I received a radio call that was there. I received a radio call that there was a shooting at that specific address. And after you received this information, what did you do? My partner and I drove to the location and then drove southbound towards the house, parking about 2 houses away from 722. And after you parked your vehicle, can you describe what happened? Yes, we exited the vehicle and started approaching, walking towards 722. We were walking along the west curb, and the house is located on the east side curb. And we made our way across from the west to the east side curb. And at that point, as sworn as we got up with a visual, and as soon as we got up with a visual and could see the house, I had some screaming. Heard some. Oh my God. Say the words, Heather. Let me say that sentence again. As soon as we got up with a visual and could see the house, I heard some screaming. And did it sound like a person screaming or more like a person? What? Did it sound like one person or more than one person screaming? I couldn't tell. And when you heard the screaming, how did you respond? Just to get a visual to see what was transpiring in front of me. And after you moved to get a visual, what happened? Then I could see from the front doors of 722 two people running from that location towards my partner and I. And when you saw these people running towards you, what happened then? Both the individuals ran towards us out towards the sidewalk area, and at that point, they were screaming something. So they weren't hiding from the police, they came running to the police. Usually, guilty people, people who believe that they did something wrong. Well, I mean, they did. Is it wrong what they did? Yes, but is it kind of justified? Kinda. I mean, it's so hard. It's such a fine line. It's like protecting people who protect or stand up for the pedos versus the actual victims. It just make me sick. So I don't know. I don't like that. I don't know how I got on that. But anyways, okay, so they both come running out of the house. Um, Both the individuals ran towards us, out towards the sidewalk area, and at that point they were screaming something. I can't recall what exactly they were screaming, and my partner and I ordered them to get down, stay down, in an attempt to prone them out on the ground so we had some control over the situation. Prone means to like lie them down. So now the two individuals that ran out of the house, do you recognize them as present in court? Yes, I do. Could you identify them for the record by where they're sitting and what they're wearing? Sitting at counsel's table in the white shirt and seated at counsel's table in the blue shirt. For the record, Your Honor, he's identified the defendants. Yes. Thank you. Now, you said that the defendants ran out of the house and they were screaming. Is that correct? Yes. And at that point, what do you recall of their screaming? Well, at that point, I was trying to get more information than what I initially received, just a shooting call. And I was trying to ask questions pertinent to what was going on in the house, suspects, weapons, things of that nature. And Miss Abramson objects and says, Your Honor, I'm going to object to all of this as not responsive. He asked, what were they screaming? Objection overruled, of course. So but now you may ask your next question, he says to Miss Nahara. So he overrules it, but says, move on. So Miss Nahara says, certainly. What did you observe as you saw them run out? They got down as they were ordered and they began to saying, oh my God, I can't believe it. Oh my God, I can't believe it. And pounding their fists on the ground, looking down on the ground, and then looking back up again at us. And were both defendants doing this? Yes, they were both were. And how long did they continue doing this? A minute, 2 minutes maybe? And what happened then? Again, I kept trying to get information and got no other response than "Oh my God, I can't believe it." And at that point, they stopped saying that, and one of the subjects said, "Just go inside and look," and pointed towards the front of the house. I think that was Lyle. Um, and he pointed towards the front of the house. Now, at this point, when they said, "Just go look inside," when you were trying to get the Ms. Abramson objects to the form of the question as misstating the testimony, court sustains it. Do you know which one they said? The witness says, no, I do not. Court says, one of them said that. Yes, says the witness. Ms. Nahara says, were they both yelling at this time? Were they both yelling at this time? Yelling, screaming, yes. And were they both pounding on the ground? Miss Abramson says, asked and answered, Your Honor, overruled. Yes, they were. Do you recall which one of them said, just look, or just go look? Miss Abramson says, asked and answered, Your Honor. And the court says, all right, I just asked that question. Ms. Nahara says, do you recall which one of them was saying, oh God, my God, I can't believe it? To the best of my recollection, I believe both of them were making that statement at some point. Now, after you heard that statement, just go look. Then what happened? At that time, my supervisor had got there along with other officers, and the supervisor made a decision that we must go in the house to look for suspects and victims, and he organized a search party in a sense of officers to enter the house. And who was the supervisor at the time? It was Sergeant Kirk West. Now, while Sergeant West was organizing to go into the house, what were the defendants doing? Another officer instructed both of the subjects on the ground to get up, and then he escorted them to the patrol car and then out of my vision. And did you see the defendants again after they were escorted to the patrol car? Yes, I did see them again. About how long after they were escorted to the patrol car did you see them? It would be a couple of hours. Hours. I maintained the crime scene at that house, and they returned to the house before my shift had ended. And that was, my shift didn't end till 7 in the morning, and they came back from sometime before that. They came back sometime before that. Now, at some point, or sometime, were there, taken to another officer named Officer Angel? Yes, that's the first officer that escorted them to probably a police car. And did you see them in the company of Officer Angel? Yes, I did. And how were they when they were in the company of Officer Angel? How were they? They looked like they were upset or distraught at that point. At some point, a few moments later, did you see them listening to another angel's directions? To Officer Angel's directions? No, I was instructed that I was going to be a member on that search team for the house, so I was told to come to a different location with the supervisor. And after the supervisor, Sergeant West organized to go into the house, what did you all do? We entered through the front of the house, several officers, and we began a search of the residence looking for, again, victims or suspects. And at some time, did you enter into the room that had been referred to as the crime scene, the den? Yes. And at that, when you went into the crime scene, did you observe the bodies there? Yes, I did observe two victims within that room. Now, was there anything on in that room? Yes, there's a widescreen television that was on. Do you recall if the lights were on? I don't recall the exact lighting in that room. When you entered the room, could you see or could you make out what was in there? Yes, I could. From just the illumination of that widescreen television, I could see, and I believe there was some lighting. I don't recall whether it was recessed ceiling lighting or what. And approximately how late did you stay at the crime scene? I stayed until my shift ended at 7 in the morning. I have nothing further, Your Honor. Cross-examination. Yes, Your Honor, says Ms. Abramson. All right, so we've got now cross-examination by Ms. Abramson of Christine 911 dispatcher. Do you know who Pamela Bazanich and Lester Kuriyama are? I believe they're the district attorneys at the trial that took place in 93. They were the district attorneys who represented the prosecution in the first trial. And did you meet them before that trial began? Okay, next question. Did you meet them before that trial began? I'm going to object to irrelevant, said Ms. Nahara. The court overrules that. Ms. Abramson says has to do with the prior statement, Your Honor. Overruled. You can answer the question. Yes, I did meet them, the witness says. Ms. Abramson continues. And were you in fact interviewed by them on September the 11th, 1991? I don't recall the date, but they did interview me at one time. And also present for that interview was Detective Leslie Zoeller of the Beverly Hills Police Department, correct? Correct. And did you notice during the course of that interview that Detective Zoeller was writing things down? He might have been. And did you ever see the report that Detective Zoeller prepared, which reflected that interview of September 11th, 1991? I might have at some point. And do you recall that in that report, it indicates that in 1991, you told Mr. Ferraro, Mr. Kuriyama, and Detective Zoller that the only lights that were on inside the house were the lights in the hallway and in the TV room? Wait, what? The TV room was dark. Everyone told us that, but now he's saying the lights were on. Do you remember that? Please repeat again on the specific lighting locations. The hallway, which is the foyer, and the TV room, which is the room with the television set. Yes. And you did tell me, or you did tell them that in 91, didn't you? Yes. And don't you think your memory in 91 about what happened in 1989 is better than it is now in 1995? It probably would be, yes. And do you also recall going back to 1989 that the television that you saw that was on in the TV room, or as we call it here, I think the den, was on very loud. I believe so. I thought it was on very loud, and I believe I said that too. That's correct. You did. Did anyone before you took the stand today suggest to you that you should say that the lights were not on in the den? No, he says. So he's not being coerced. Okay. Now, do you recall as well in the conversation that you had with Mr. or Mrs. Ferrero Bazanich, you understand that she was Pamela Ferrero at one time and got married and became Pamela Bazanich? If you say so, I believe it to be so. I have no reason, or you have no reason to doubt me. District attorneys do get married, yes. Do you recall during the interview that you had with the previous district attorneys on this case and with Detective Zoeller that you said to them that when Lyle and Erik Menendez came running out of the house, they were saying, "My parents have been shot. My parents have been shot. Go in and see." I don't recall saying that. I remember saying part of that to go in and see. Someone's been shot, is all I can recall. He just repeated back what the question was. Okay, would you concede that if Detective Zoller wrote down these words, "My parents have been shot," that is likely that you said that at least on September 11th, 1991 during the interview? Yes, I made the statement back in, I'd probably be more accurate than yes. And is it, let me see if you have a current recollection, Officer Butkus. Do you remember that Erik and Lyle Menendez were shouting words to the effect to go and see as they were running out or only after they were down on the ground for some time, some period of time? I believe it was the same time duration when they first came out on the curb at the front of the house when I had good vision on who I could see. And within that time, and then getting down to the ground like I told them to sometime in there. Abramson asks, "Okay, you were asking questions and they were not really answering the questions, and eventually one or both just go and see." He says that's correct. Did either of them, you said you were attempting to prone them out? I don't know if the jury understands what prone out means. What does prone out? Proning out in that situation, you have shooting guns. Proning out would be something where I ask or tell someone to get down on their belly on the ground and their arms down so I have some type of control and you can see their hands and such. At first blush, you didn't know if these persons were suspects or victims. I did not know. And is it standard and procedure for more police department than when you have that kind of ambiguous situation for the safety of the officers, you want people lying flat on the ground with their hands showing so they can do anything to you, so they can't do anything to you? He says, "I don't know if it would be the department's policy. It was my reference at that point with what I saw going on. But this isn't the only time where you ever asked a suspect to get down prone, did you?" I didn't know who I didn't know who was a suspect or my point is, this is routine for you. When you feel that there's a possibility of danger, you have a suspect go down on the ground and so you can examine the situation. Further, certain circumstances I know of, yes, like I mentioned, guns, shooting, and as you heard, this was the shooting, so that was not out of context to do that this was the case, right? Correct. Now, you started to tell us sometime after you saw Erik and Lyle Menendez go off with their officer Angel, you saw You saw them back at the premises. Yes. And were they in the company at that time of someone that you understood to be their tennis coach? That's what I told them. And there was an adult male with them, correct? Friend. Yes, friend, tennis coach. A grown up though? Yes. And were you present when one or both of the Menendez brothers asked some other officer if they could get some clothing and tennis rackets from the house? I wasn't present to hear the Menendez brothers make the statement. The other officer inferred that to me later. Who was that officer? I don't recall, but he was directed. He immediately told the lieutenant at the scene, Lieutenant Salcedo. Salcedo. So you saw, after you saw Eric and Lyle Menendez and this adult who was identified to you as a tennis coach there, then you saw another officer approach Lieutenant Salcedo? Yes. During any of that part, did you see Detective Zoeller? Nope, not at that time. Did you ever see at that time either or both of the Menendez brothers with or without their coach talking to Detective Zoeller? No, I don't recall seeing that. Where were you posted? Where were you seated or standing when you noticed Eric and Lyle Menendez and the coach at their premises? I wasn't positioned in an immovable spot. First, I was at the front of the house and the crime tape was put up in the point at the front of 722 and it stretched all the way onto the curb line and then up the street and they came up to the curb line and they could not get through the crime scene. Well, I'm sorry, but they need to preserve the scene and usually you start out big and then you eliminate so you can narrow in to your target where you think you're going to find something. So there was another officer positioned there. Question. They came up to the curb line at the front of the house by where the crime tape was. Is that the front of the house? Yes. So you were at the front of the house at one point. At the point when you saw them and the coach? Yes. That's all I'm asking. If you were in front of the house on Elm Drive? Yes. And you saw them approach that way? Yes. And then they couldn't get past the tape. So do you see any other officer approach them? Yes. And did you see them go anywhere after they were approached by that officer, or did they remain there at the tape? No, they remained right there at the tape. And did you see them subsequently leave? No, I did not, because I walked back to the very front entrance of the house. You mean you walked, well, tell me where you were before you walked to the very front entrance. Well, when they approached again, I, like I say, the crime tape was put up at the curb line of the house where the little grassy median is, and I was there at one point when both subjects did come up to there. Okay, and then you saw them there with this adult male? Yes. You saw them having some kind of contact with another officer? Yes. Do you see the lieutenant go over to where they were? Yes. And when you went to the front of the house, and then when you went to the front of the house, had to walk back across the grassy median, across the curb, across the front of the house, the long driveway, and back up the front door. So you went to the front door. Did you ever see Eric or Lyle Menendez come up to the front door at that time? No, I did not. Did you ever see them inside the house? No, I did not. After you went to the front door, where did you go from there? I stayed in that area for the remainder of the shift, just about. And were you outside the front door on the area just in front of the door? I was outside, and then I had to go inside where the coroner was. At that time that you were outside and you continued to see Lyle and Erik and the coach and other officers at the tape line uh, at the curb? No. Did you at some point see Lyle and Erik Menendez and the coach walk away from there? I did not see them walk away, but I did. I looked at one point and they were not there anymore. Okay. Court says, how much longer do you think your examination will be? And Ms. Abramson says, just a moment or two, Your Honor. I don't want to have the witness come back. So just a moment. And the court says, okay. Ms. Abramson says, at the time when you told Erik and Lyle Menendez, you get down, did you have a gun drawn? Or when you told them to get down, did you have a gun drawn? He says, I did have a gun out, but it was not drawn at anybody. I believe I had it on my side. So you meant it was out of the holster in a ready type of position, but down at your side. Yes. How about your partner? Was he doing the same thing? I don't know. Shouldn't you know like what's going on all around you in these situations? He says, let me ask you this. Officer Butkus, when you pulled up to your Elm Drive, were your partner the very first units there, or did you see other patrol cars near the house? No, our patrol car was the first car on the scene. How come we're just learning this now? I mean, I knew this, but I don't know if I told you guys that. But it was in the quiz or the poll. And were you in communication with the dispatcher at the time that you pulled up? Yes. And were you aware that the dispatchers were calling the people inside the house and telling them that they were there and to leave the house? I wasn't aware of that, no. Miss Abramson says, I have nothing further, Your Honor. The court says, anything on behalf of Lyle? No, Your Honor. Again, like, why are you not cross-examining these witnesses at the very least for your client? You suck. This whole team is not really advocating for Lyle, and I don't like it. The court says any redirect. Ms. Nahara says briefly. Ms. Abramson says, I did have one question. Do you have any idea how long before the end of your shift at 7 it was that you saw Erik and Lyle Menendez and the coach at the property? He says, no, I couldn't give you a specific time. He asks if there is any redirect. Ms. Nahara says, thank you, Your Honor. Redirect examination, Ms. Nahara. It's asking questions. You've heard Ms. Abramson refer to your seeing the defendants, Erik and Lyle Menendez, at the crime scene along with an adult. Is that correct? Yes. And at that time that you saw Erik and Lyle Menendez, they were also adults. Is that correct? Abramson says, I'm going to object that it's beyond his personal knowledge. The court says, well, in your opinion, do you have an opinion about that? The witness says they looked like adults to me. Ms. Nahara says, now you testified at a grand jury. What the hell is an opinion on being an adult? You're either an adult or you're not, and his opinion on whether he's an adult or not doesn't matter. Ms. Nahara says, now you testified at a grand jury proceeding in this matter on August 10th, 1992. Do you recall that? I I did testify at a grand jury. I don't know that's the specific date, though. And at that time, did you testify that when the defendants came out, Miss Abrams says, excuse me, if counsel is going to recite to a page of testimony, I'd like, the court says, what page? Miss Nahara says, I'm not citing the exact page, I'm just citing the quote. Ms. Abramson objects. Court says you don't have a page reference, but you have an exact quotation. Ms. Nahara says, yes. The court says you may cite the quote. Of course. Ms. Nahara says, on August 10th, 1992, before the grand jury, did you testify that the defendants came out and hollered, oh my God? Yes. Ms. Abramson says, I'm going to object to that. That misstates the testimony from the grand jury, and I do have a page citation. Court says, overruled. You can cover that on recross. Ms. Nahara says, and did you testify at some point, Miss Abramson says, Your Honor, I'm going to object. Also, on the grounds of hearsay, no exception. Court overrules her again. Ms. Nahara says, and as you sit here, you recall that you heard them hollering, Oh my God, I can't believe it. Is that correct? That was one of the phrases. And did you hear them holler the phrase, I can't believe it, someone's been shot, or words to that effect? I'm going to object, Your Honor, as calling for hearsay. The court overrules her again. The witness says, I don't recall that specific phrase. I can't remember that specific phrase, but something like that. Ms. Nahara continues her questioning. And is it fair to say that they were hollering many variations of this when they were out there on the grass? Yes. And with regards to the crime scene itself, you said earlier that there was recessed lighting and there was light from the TV. Do you recall that? Yes. Do you recall as you sit there where the recessed lighting was? Well, the recessed lighting would be in the ceiling of the room you're calling the where the TV was. So the den. Do you recall there was any lighting in the foyer? There was lights on in the hallway, is what I could tell, or I would call it. Ms. Nahara says, Thank you. I have nothing. Further recross examination by Ms. Abramson. She says, You made the statement to the previous deputy's district attorney in September of 1991, correct? Are you citing the grand jury or no, I don't want to confuse the two. That's the point. The first statement that you made concerning what you saw and what you heard that night that you made to other people was the one on September 11th, 1991 with the two the district attorneys and Detective Zoeller. He says, and Detective Zoeller? Yes, and yes. Okay, you didn't testify before the grand jury until almost a year later, August 10th, 1992. Do you recall that? Yes. Okay, so it is possible that your memory had already faded somewhat between the statement that you gave the district attorney and Detective Zoeller in 91 and the later testimony at the grand jury in 92. It could have. Miss Abramson says, That's all, Your Honor. The court says, Okay. Ms. Nahara says, Just one question. For the redirect examination of by Ms. Nahara, she says, Officer Butkus, with regards to your grand jury testimony, do you recall stating that you heard them say, Oh my God, I can't believe it? He says, I remember. Ms. Abramson says, I'm going to object as beyond the scope. The court says, All right. It's already been covered. You've already asked the question about what he testified to. It's beyond the scope of recross. Ms. Nahara says, Nothing further, Your Honor. The court says, Okay, thank you. You may step down to Michael Butkus. You're excused. We'll be in recess until tomorrow. Um, so we'll be in recess until tomorrow, ladies and gentlemen. Do not discuss the case with anyone. Don't form any final opinions about the case. Do not look at or listen to it or read it, anything about the case in any form whatsoever. We'll see you back here tomorrow at 8:30. The jury exited the courtroom and the following proceedings were held. So we're going to have a little bit of argument here and then we're going to go trickle over into day October 17th, Tuesday, October 17th testimony, and we'll have some argument there too. I think you guys, who was this? Averill Crum, I need to wait for your opinion on whether we do Averill or not. So we'll start arguments there, and then that should end us. So we'll do some arguments for the end of the day, and then the beginning of the day for the 17th, and then we'll stop there. So we are on 322. Court says, okay, this is day 16, October 16. The court says, okay, as to the schedule for tomorrow, who is that you propose to call? Ms. Nahara says, we propose to call Perry Berman tomorrow, Your Honor, and Officer Edmonds, and we still need a decision on Ms. Pisarcik, what we're going to do with her, and Ms. Crome. Ms. Crome, we will be calling. Court says, Berman and Edmonds and Crome in the morning. Is that right? Ms. Nahara says, that looks about right. Yes. Court says, and who else do we have scheduled other than Pisarcik? The bailiff says, may I interrupt just for a moment? The court says, yes, let them go. The jury exit the jury room. The court says, who else do you have? Ms. Nahara says, Your Honor, we can get Mr. and Mrs. Wright in. Ms. Abrahamson says, Your Honor, we're a little puzzled by the prosecution's estimate of 4 hours for Perry Berman since he testified for a total of 35 pages of transcript at the first trial. We're wondering, does that mean there's something we don't know, some discovery we haven't been provided with, some additional information that they expect to elicit? The court says, do you expect his testimony to be substantially different than it was the first trial? Substantially longer or cover areas that weren't covered? Ms. Nahara says, no, Your Honor, my only concern is he goes through a lot of detail and a lot of exhibits, and judging from what we just observed with Detective Zoeller, Ms. Abramson says, how in the world? Ms. Nahara cuts her off. I just assumed it would take a while. If they say that it's less, that's fine. The court says, the only inquiry is whether you expect it to be much different than it was in the first trial. Any new discovery? Ms. Nahara says, there's no new discovery. Court says, all right, as far as Pisarcik is concerned, I'll hear what the people's motion is as far as why the material from Detective Zoeller wasn't turned over before this afternoon or this morning. Ms. Nahara says, Your Honor, with regards to Ms. Pisarcik, who's talking again? Ms. Nahara. So the state is saying, in regard to Ms. Pisarcik, we had a conversation with her, we being the group of us. It was an informal conversation. Detective Zoeller was in and out, as he will tell you, for the conversation. He missed part of it, and the end of the conversation, I wasn't actually taking a lot of notes on this because it wasn't an interview type of thing. It was more of a getting basically to know her and finding out what she really was going to be able to testify to or not. At the end of that, she told me she looked at transcripts and these were things that she felt were different. I took I took down the list of things that she told me were different. I wasn't aware we were again going to write a report about this, and I realize now Detective Zoeller was taking notes such as they were. If the court looks at those notes, they were real sketchy. It really wasn't something we were preparing for a report, if you know what I mean. The court says there were notes. What would be the reluctance in turning over notes of an interview of a witness? Ms. Nahara says there would be no reluctance. I wasn't aware he was taking them. As he will tell you, he was in and out. The court says this is on the phone or in person. This was in person. Court says, didn't you see him writing notes down? Ms. Nahara says, we were in the library. He was at one corner and I was at the head of the table. Quite frankly, I wasn't really paying a lot of attention to him. Why is it such a big deal that he's writing notes down? The court says, are there any other witnesses that you've interviewed with Detective Zoeller or he was interviewed for you or that he was present for or that he was present for when other people were being interviewed? So is that what the defense is saying, that s- the witness, one of the witnesses, was being interviewed while Detective Zoeller was there and he was taking notes? That would be his notes would be discoverable then in that case. And so, but that's what I guess what she's arguing against. So she's saying, let me read that again. The court says, are there any other witnesses that you've interviewed with Detective Zoeller or he has interviewed for you or that he was present for when other people were doing interviews that resulted in his taking any notes that haven't been turned over to the defense? Miss Nahara says, not that I'm aware of. Can I? And then she confers with counsel. She comes back and says, Your Honor, there was an interview. No. Miss Abramson says, Excuse me? No. No, no. Mr. Khan says, No additional notes. The court says, Okay, as far as the defense requests for sanctions, let me hear what it is that the defense has to do in order to prepare for this testimony of Pisarcik that you wouldn't otherwise have to do. So now the defense is claiming they got to do something to prepare for Jamie Pisarcik's testimony, which is leaving them calling for sanctions against the prosecution. Ms. Towery for the state says, Well, Your Honor, from what Ms. Nahara just said, basically, isn't she? Wait, hold on. I'm still trying to remember. Is Ms. Towery is Lyle's attorney, right? I went to the wrong thing here. Yeah, Miss Towery is Lyle's attorney. Get out of here. I didn't mean to open that. Okay. So Ms. Towery says, Well, Your Honor, from what Ms. Nahara just said, basically there's potentially additional information that Ms. Pisarcik gave to Ms. Nahara that wasn't taken down when Detective Zoeller was out of the interview. The court has seen the notes that Ms. Nahara provided to us. She indicated to me, as I told the court yesterday, that she destroyed her original notes and that the typed single half page discovery that was provided to us was a verbatim transcript of her notes, was all the discovery available. We then almost accidentally found out just by virtue of the fact that Detective Zoeller was in the courtroom and volunteered that he had these extensive notes of the conversation today. There's a lot of information in these handwritten notes, which I would point out are not completely decipherable at this point. Obviously, although Detective Zoeller's handwriting is much better than my own, it's difficult to read someone else's handwritten notes and particularly make sense of them without them being written up in a formal report. However, to the best that I've been able to determine today in the free time that I've had to read through the notes provided by Detective Zoeller before lunch, there's quite a bit of new information, provided in these notes that we were unable or unaware of previously. For example, on page 2, do you want me to go through and point out all of the different instances? The court says, no, no. Ms. Terry says, I have a number of them, as you can see. The court says, I assume that the prosecution didn't intend to go into any of that material in its examination of the witness, or that they would have included it with Ms. Nahara put in her notes. Ms. Abramson says, I wouldn't rely on that. Truly, I wouldn't. Ms. Towery says, I think we should inquire. I don't know. However, there is additional information regarding at least one of the three aspects that the prosecution did intend to go into with Ms. Pisarcik in her testimony in their case in chief, and that is there's an entirely new description of her conversation with Lyle Menendez she testified about at the last trial and gave a statement under oath to deputies, District Attorney Bazanich and Mr. Kuriyama, regarding the supposed transfer that she testified about the scene in the movie. And that's the notes that we've been provided, the pages are unnumbered, but that's on page 5. It's a scene in a movie. And it indicates, well, I don't want to indicate in open court what it says, but And then the court cuts her off and says, "Let me say this. Without going any further at this point, I want the prosecution to identify any material that was contained within Detective Zoller's notes that you propose to bring back to you for the direct examination of the witness, or that you would anticipate being brought out in redirect of the witness ban, nope, of the witness based upon the type of cross-examination that occurred during the first trial. You can do that tomorrow morning by identifying in a photocopied version of the notes of Detective Zoller by underlining what it is that you intend to bring out in those notes in her direct and redirect. However, I am certainly going to provide the defense with ample opportunity to digest this information and prepare for her examination. And if it requires rescheduling of that examination or delaying it, or some other means or response by the court, I'll deal with that. But at this point, I want to make certain that we have sufficient number of witnesses to cover the days ahead without recourse, blah, blah, blah. So you better have other witnesses available. You've identified Berman, Edmonds, and Crum, and possibly the Wrights available tomorrow. Ms. Abramson says Edmonds also has 2 tapes to play. Court says, I recall that, but they're not that long. Abramson says, the people have given us the transcripts of those, and I don't see a problem with those transcripts, Your Honor. They're identical to the ones used last time. Court says, well, we'll be in recess until tomorrow. Mrs. Towery says, could you just address one issue? Court says, yes. Ms. Abram indicated her concern about Perry Berman the last time, or about Berman's time estimate being 4 hours, and I would like to reiterate that concern. The totality of his testimony at the last trial was 35 pages. Now, I don't know how one could estimate it 4 hours from that. So it's way overestimated. And I'm very concerned that we may have another situation where somehow we haven't been provided with notes or reports or information that may be coming out for the first time in front of the jury. To the court, or the court says, well, I've asked and I've been told by the prosecution there is nothing else. Is that correct, Mr. Khan? Mr. Khan says there's no new material. That's correct. They have all the discovery in the case. Any additional material is going to be found in the interview that we conducted with him some time ago, which we turned over to counsel. Ms. Nahara says, that's my only concern. We did a later interview, which we turned over. I don't know if counsel remembers it. Court says, I assume if you turned it over, they have it. We'll be in recess until tomorrow at 8:30. Ms. Abramson says, is the court still considering the suggested order that I submitted about limiting the attorney's speech? The court says, well, I've received it, really haven't had a chance to review it, and at this point, I haven't been made aware of any conduct that would rise to the court making such an order. Abramson says, I'm not asking for a gag order, only trying to prevent prejudicial speech and the language in that order. The court should know has come from an amalgamation of the attorney extrajudicial statement rules that have been adopted in the number of states. The rule in California states that attorneys are prohibited from making statements that will have the substantial likelihood of materially prejudicing the trial. Ms. Abramson says, I know, I just wanted to spell that out. In some states, they actually indicate what kind of speech is believed can do that. Now, the court says we have our state bar rules, and if we want to promise an order that would, as I said last time we decided it, an order that would track the language of the state bar rules, I'll consider that as well. We'll be in recess. I don't know what he's talking about there. All right, so that's the end of Monday, day 16. We're moving on with week 2. We're going to start up this the morning, October 17th morning arguments. They have a few pages here before we get to the first witness, which is Avril Crum, and I need you guys to let me know if we should record hers. So look for that poll. All right, so we're on October 17th. Get my highlighter here. I like to highlight. All right, so Tuesday, October 17th, we are on week 2. Court says, in the trial without the jury, the lawyers are here. What do you want to talk about? Ms. Naharis says, yes, Your Honor, yesterday you instructed that we go through the 14-page report, or actually the 14 pages of notes which Detective Zoeller has provided. I believe it was the day before yesterday to the defense. My guess, I need some clarification. My understanding was that the court wanted to know what we were going to use from this report that in our direct examination and to underline it. As I was going through the report, I realized that much as I had thought earlier, it appears that these notes really are all of these notes deal with old subjects that we've already discussed, and basically what they do is they add a little information or a little clarity to old subjects that have already been discussed, but for the issue dealing with the hair replacement conversation and whether or not Lyle Menendez wore a wig or not, that's something which we've all agreed would come in rebuttal, and that appears in 2 places in these reports, in these notes, I would say. But for later, all of the other information here appears to be information that was covered in both the original statement taken by Ms. Bazanich and Mr. Kuriyama and the testimony of Jamie Pisarcik. Now, as I said, the information, the subjects are all the same. It's just there's some clarification and a little bit of added information, though I think that's probably wording it too strong. I wasn't sure if the court wanted to. I know if there was anything new that we saw as new, or what really the court was interested in terms of what we had. Counsel stated yesterday that they thought it was substantially different, and for that reason they needed a continuance to be able to go through it and determine that was substantially different. For the record, Your Honor, it appears to cover the same issues, which are basically the issues concerning the research that Jamie Pisarcik did for the defendant, Lyle Menendez, while he was in jail. The fact that she went or sent him certain books from certain places, all of this was covered once before. The fact that he made a statement requesting that she commit perjury. So this all happened after the first trial. Obviously, when Lyle was in prison, he was talking to Jamie Pisarcik over the phone, and she admitted that he had basically he wanted her to lie, and he wanted her to do some research for her regarding um, symptoms and reactions and things, and he wanted some research on SA and trauma and what that does to people, basically. So I don't know what exactly his ask was, but something along those lines. And then finally, and also the fact that that basically he made a confession to her. These are all 4 big topics, and there are a lot of little information, background information that lead up to that. That's basically what these notes were about. The discussion was about, and I don't see anything here that was substantially different from that. Counsel feels they need a continuance for, and I'm not quite sure if the court is aware of that. And our feelings is that those subjects, as well as the accompanying background information, is what we would elicit from those notes. which is basically all of the notes, save for the areas that I've just stated we wouldn't go into because that was more appropriate for rebuttal. The court says, well, the way this started was the prosecution held back in the interview notes and the interview of Ms. Pisarcik until Friday afternoon, and the reason we're having any of these discussions at this stage of the proceedings is because the prosecution delayed in turning this material over, and I really have not heard any good reason why not, other than negligence on the part of the prosecution. Finally, yelling at the prosecution. It's about time. And that was minor. That wasn't even yelling. All right, so so Mr. Khan says, Your Honor, we interviewed her on Thursday. It was Thursday that we interviewed her. The court says, okay, then maybe I'm misunderstanding. I thought the interview of Eslamania was recent. Ms. Abramson says the other way around, what they did is they gave us 3-paragraph notes instead of giving us Detective Zoeller's notes. The court says, so Zoeller's notes came on Friday. Ms. Abramson says, no, yesterday. Ms. Towery says, yesterday. The court says, Monday. Okay, so Mr. Khan says, we interviewed her on Thursday. By Friday, Ms. Nahara gave them what she felt might be significant. The court says, okay, I understand now. I apologize for the reference to the delay by the prosecution and negligence it had to do with Eslamania. As far as the reasoning for this discussion, it's because the prosecution now appears to have changed its offer of proof from that which was subject to pretrial litigation, and that is more than anything else the reason for any hearings that are necessitated by this late notice. Originally, when Ms. Pisarcik testimony was offered by the prosecution prior to the commencement of the trial, it related to the solicitation of perjury and the admission of taking their parents' lives. Those were not the two items that the prosecution indicated it would offer, and there was litigation and objections by the defendant, the non-declarant defendant, as to denial of right of confrontation and implication of him in criminal conduct by reason of statements made by the declarant. And we had hearings and rulings on that based upon what the people's offer of proof is or was at the time. And now the people, from what I hear, really don't know anymore now than they did when they originally made the offer of proof, but have changed their mind as to what they're offering. Is that correct? Ms. Nahara says that is not quite correct, Your Honor. He says, what is incorrect about that? She says, well, here's the issue. My understanding is the original ruling that the court made as to the first motion involved the perjury and the suspending, and the court said that that was, in fact, admissible. Then an Aranda issue arose. The defense objected to the confession on Aranda, and that was the ruled assembly. That was ruled admissible. That was ruled admissible. The only issue, and it really wasn't an issue, involving an Aranda problem or any kind of prejudice problem as to the other defendant was the issue of the research and whether or not that should come in. That's my understanding of whether the court interrupts and says, when was that discussed? Ms. Amerson says never. Ms. Nahara says the issue of the research was not discussed. Court says, how did it become an issue? How is it an issue? Ms. Nahara says, I didn't realize. The court says, remember, in this first trial, she didn't testify until rebuttal, so all that came in rebuttal. So there was never an issue of distinguishing rebuttal versus people's case in chief. So how did it, I don't understand how it suddenly became an issue. Ms. Nahara says, that's my point, Your Honor. To me, it was never an issue. It's just something we were planning to issue. Okay. It's not an issue, but it's something we were planning to issue. It wasn't anything that had any legal ramifications involving Aranda, and there wasn't anything that anyone had objected to about that. Like, no one had said that that it was improper with regards to rebuttal, it wasn't an issue. Now they're saying this is something new. They've known about it all along, and it wasn't anything they ever objected to, Your Honor. The court says, was it part of your offer of proof? That's what I'm asking, because the problem of notice is so that the defense can object before trial. These were issues relating to severance, and the issue was whether or not you gave notice to the defense that this was something that you wanted to introduce during your case in chief. Mr. Khan says prior to the start of the trial, the court invited the people and invited the defense to raise as many pretrial issues that we can so that we can avoid the number of pretrial issues that we'd have to raise at the time of trial. The court says correct. Mr. Khan says, and that's what the people did. And the people filed with this court voluminous motions dealing with many, many, many issues that we felt would arise at the time of trial. What we represented at that time was not that was our entire case that we intended to introduce, nothing more than what we were raising in those potential or pretrial motions. We were raising issues which we foresaw as issues that would arise at the time of the trial that we wanted to deal with as early as possible. That is why we focus on those issues. As far as the particular issue is concerned, I don't see that this is an issue. I don't see that this is something that should be excluded. If the defense feels that this is something that should be excluded, it was incumbent upon them to raise the issue prior to the start of the trial. I don't think that we were precluded. I don't think that we were precluded from raising it now because we were not representing at any time that the issues that we raised before trial are the only issues that are going to arise in the course of the trial. The court says I'm not saying that. All I'm saying is that the way the matter was presented certainly gave me the impression that all that your offering of Pisarcik was that which was subject to the people's offer or proffer of evidence, and that's what I intended it. And I assumed the defense did likewise. So I view it now as the prosecution adding to the initial offer that was made, and I'm not foreclosing it. I'm just saying that the defense should have a right to state their objections and we would have a hearing. Mr. Khan says, and I have no problem with that, or with them stating that. I would just ask that we do this today so we can put Ms. Pisarcik on this afternoon. We would like to fill up the time. I think when we get into the rights this afternoon, they're going to fill up a good portion of the time, but if we can resolve the Pisarcik matter, I would like to get her into her testimony today. Court says you're not going to get both Pisarcik and the rights on today. Once you get into Pisarcik from the nature of her cross-examination in the first trial, she'll take quite a while. Mr. Khan says, if we can start with her today, we can finish her tomorrow. The court says, you want to start with her? Stop and put on the rights. Mr. Khan says, no, I think we have enough to put on this morning. We can start with the rights at 1:30. When they're finished, we can start with Pisarcik. The court says, we can deal with Pisarcik, but again, we have the jury. I assume they're all here. Bailiff says they're outside, Your Honor. Let's get them in. Enters the jury. Or they entered to the jury room. They're not in the courtroom yet. The court says, okay, let me hear the defense's response. Ms. Towery says, thank you, Your Honor. Initially, Mr. Khan indicates that it was incumbent upon the defense to raise these issues prior to trial, and we did precisely that. In our motion that I mentioned yesterday, our motion in limine, asking the specific question and objecting to the prosecution offering what we consider to be rebuttal evidence in their case in chief. And my impression, as the court has indicated, was the court's impression was the same, and that was that the prosecution was only offering the areas which they had indicated to the court that they were offering evidence on. As a matter of fact, at page 9 of their brief, in response to their brief objecting to any rebuttal type testimony via Ms. Pisarcik, the prosecution responded that the and I'll read it to the court. The efforts of Lyle Menendez to solicit perjury from Jamie Pisarcik will be presented by the people and has been ruled admissible by the court. In a separate motion we are filing today, we also contend that the admission of Lyle Menendez that he took his parents' lives is also admissible, and that second piece of second proffer was litigated on August the 16th before this court. And we all relied upon the people's indication that those two pieces of evidence plus spending or that is the purchase of the sob for Jamie Pisarcik was the defense conceded was admissible in the case in the people's case in chief were the only three areas that they intended to prove. Now, we have additional discovery. First of all, we find out that the prosecution intends to go into the supposed research by Lyle Menendez regarding his defense. That's what it was. He wanted some sort of research in his defense. I don't know what specifically, but whatever that is, they want to bring it in. So we have considerable additional discovery regarding that issue and a number of other issues which the prosecution seeks to raise either in their case in chief or in potential rebuttal. The research aspect, however, Your Honor, has quite a bit of additional information implicating two former attorneys for Lyle Menendez in some sort of apparently improper conduct on someone's part, both Paul Mones and Ms. Lansing, which we, of course, need to contact both of them and discuss their recollections regarding what occurred in this case and the timing of the events that are described in the additional discovery. In addition, Your Honor, we have a 352 objection to the research testimony in any event. It seems to me that the order to be relevant, well, the testimony that was offered at the previous trial was that via Miss Pisarcik that Lyle Menendez asked her to go to the library and look up cases involving situations where children had been acquitted after taking their parents' lives. Sorry, dog stepping and like I don't know if you hear it, but it's so distracting to me, so it's annoying. Um, Let me back up. So, well, the testimony that was offered at the previous trial was that via Ms. Pisarcik that Lyle Menendez asked her to go to the library and look up cases involving situations where children had been acquitted after taking the lives of their parents and that those children had been essayed by their parents. That was the sum and substance of the testimony. I don't think that that's a bad thing that he did some research on that. That's it. That was actually a lot more innocuous than I thought it was. I thought he was looking up stuff about like how to, stuff about trauma, but no, he was actually looking at like other cases similar to his. So that I don't understand how that's against the law. So the court says, right, that was offered only as to Lyle Menendez's jury. Ms. Abrams says that's correct. Ms. Towery says that's correct, Your Honor. That's one issue that we've never litigated, whether or not that would be admissible or a 352 analysis would permit it to come in now that we have a single jury and Erik Menendez is present. And I think that's a substantial issue. That's something that Ms. Abramson will need to address more fully. But it also seems to me, with respect to Lyle Menendez, that the people seek to draw something sinister from that type of behavior on the part of Lyle Menendez. It seems to me that the probative value of that type of evidence is outweighed by the prejudicial effect. There is nothing sinister about him participating in research regarding his defense. In fact, he has a constitutional right to present a defense and he should participate in his own counsel. The court cuts him off. All right, I don't want to get into the details. Ms. Towery says, well, that's my point, Your Honor. The court says, I understand there is an objection. I understand there's a need to investigate. I understand there's an objection on the part of the other defendant to the introduction of the evidence. Those are things that would have to be litigated in a hearing, and I'll be more than happy to set aside some time to do it. But I'm not going to do it this morning if we have other witnesses here and we have the jury here. And this is, as I indicated before, a change to the people's position as far as the court is concerned, as far as the defense is concerned, and legitimately would necessitate some litigation. Ms. Towery says, "That's my position as well, Your Honor." In addition, there was one other point, though. The prosecution indicated, I believe, yesterday that they intend to use a clip of a movie, the movie that was the subject of the supposed solicitation of perjury. And again, that's never been shown to the defense. It's never been proffered. And we would need to litigate that as well. I think that we do object to them using that movie. There's no indication that. The court says, all right. That would also be part of the hearing. Ms. Towery says, exactly, thank you, Your Honor. The court says, okay, who are the witnesses you have for this morning? Ms. Nahara says, Your Honor, we have Ms. Crom, that's the neighbor who heard the gunshots but thought they were fireworks. And then we have Mr. Perry Berman, and I believe who we're going to read. He's a key witness, so I want to read through his regardless of whether you guys really want to or not. I mean, I hope you would want to hear his. He was the person who the brothers used as their alibi. So we'll listen to his testimony. Um, and yeah, Ms. Nahara says, and I believe we're getting Sergeant Edmonds here this morning. The court says, okay, all right. As I said, we'll try to set aside time for this, but I want to give the defense an opportunity to respond. There are issues that relate to the testimony of Pisarcik. I'm not so sure I agree that this is not proper evidence in the people's case in chief in general, without regard to the 352 objections and other issues that relate here or have been stated here. I don't know if it's much different than the solicitation of perjury in a general sense, as far as whether it should be on rebuttal versus the people's case in chief, but that's a separate issue. As part of the overall discussion we can have, but I don't want to interfere with the flow of the trial and the fact that we have the jury here at this point. This is new material and not such that the court feels that it would be proper to force it on the defense before they're able to respond to it and prepare for this. If this was just the evidence that the people indicated they would be offering, as they indicated in their proffer of evidence, then obviously there wouldn't be any need for further litigation at this point. Ms. Nahara says, and Your Honor, for the record, when we say new material, we don't mean it's new material in something that they've never heard before. It's merely new material as to what we've litigated before. Ms. Abramson says, some of it we've never heard before. The court says it's both. First of all, as far as the movie you want to use, that's new material. You've never shown it to the defense. They have to see it. As far as the details relating to Moans and Lansing, that's new and has implications that the defense certainly has a right to investigate before they respond to it. So we'll set a hearing for it, but I want the defense to indicate to me when it is that they are going to be ready for this. I don't want to protract it and delay it just to interfere with the completion of the people's case, but at the same time, I want to give the defense an opportunity to respond to it. So you can think about that and we'll discuss it further at recess. But are we ready with our witness? Mr. Khan says yes. Okay, we'll take a break until 10 minutes after a 4-minute recess, and then we'll come out with the jury. Ms. Towery says, Your Honor, there's one more matter. Before Mr. Berman testifies, there's something we want to bring up. Ms. Abramson says, and before Detective Edmonds, the court says, well, who's next? Crom. She's short. Who's after her? Berman. Let's do this now then. If you have something on Berman, what is it that you want to discuss regarding Berman? Ms. Towery says, Your Honor, the most recent police report that we received respecting Mr. Berman indicates in it that Mr. Berman, I'll find the quotation, Mr. Berman told Detective Zoeller and the district attorneys in March of 1995 that, and I'll quote from the police report, Lyle said to his father, told him that he would cut him off financially and take him So Lyle said that his father told him that he would cut him off financially and take him out of the will, and this was relating to the relationship with one of his girlfriends, Christy. And the next sentence says, Perry then said that he wasn't sure whether Lyle had told him this or whether Christine told him this. Given the fact that Mr. Berman has indicated that he does not know the circumstances, the court says, let me ask, do you intend to bring that in? Ms. Nahara says, yes, we do, Your Honor. The court says, how would you do that if he's not sure who said it? Ms. Abramson says, they'll make him sure. Like, they'll make him sure. Ms. Nahara says, I'll recheck with him. My understanding is, his understanding is that it was Lyle Menendez who told him that, but we'll recheck again for a third time and get it completely. Ms. Towery says, rather than Ms. Nahara rechecking today, Your Honor, could we have a brief 402 hearing with this witness and ask him? The court says, when was the report prepared? Ms. Nahara says March 15th, Your Honor. The court says of 95, correct. And you haven't spoken to him since? Ms. Nahara says, I personally have not, no. The court says, has anybody from the prosecution or police? No, no. We did not interview him, no. The court says, it seems to me that it doesn't require a hearing. Just ask if the specific question is asked of him. Did Lyle Menendez say something to you regarding inheritance? He can say yes or no. Ms. Abramson says that's sort of leading. The court says that's how you focus on what issue. uh, Seriously, that is a leading question. And she's objecting to that. And he's like, well, but that's how you focus on that issue. So then he can say yes or no. Like, but that's how you do it. But that's leading on, Your Honor. He's like, well, what do you want me to do? That's how you're supposed to do it. The problem is that's asking in a suggestive way. The court says it's going to be suggested in the 402 hearing anyway. We're not just going to ask him all this testimony. He would focus on that issue. Ms. Tari says, I think in the 402 hearing we would say, do you know whether or not Lyle Menendez told you this or Christy told you this? If he says, I don't know, then the issue is solved. If he gets in front of the jury and says, yes, Lyle Menendez told us that, it doesn't do us any good to get up in cross-examination and have him say maybe Lyle told him or maybe Christy told him. It's just double hearsay if Christy told him because presumably Christy got her information from Lyle, or that's what the jury will presume. It's even more damaging. Ms. Abramson says, Your Honor, there's also, as I've indicated to the court before that, we're aware of the fact that all sorts of witnesses in this case are fudging on their testimony or changing previous statements after contact with Ms. Nahara. Oh, people are changing their statements after talking to the prosecution's office. And we would want, if they're going to be allowed to ask them this question, not in a 402 hearing, we want the court to require that it be present as well. The court says, well, I'm not going to require that. The people certainly can do their interviewing whenever they want. Do you have any idea how long his direct examination is going to be? Ms. Nahara says, I'd say about 30 minutes, Your Honor. Ms. Abramson says, during the course of this discussion, the record should reflect Detective Zoeller left the courtroom. I don't know if they're checking at the moment. The court says, as I said, if they are, that's fine. That's more than appropriate for them to do that. Ms. Nahara says, thank you, Your Honor. I'd say to be careful, 30 to 40 minutes. The court says, and Crom's testimony is how long? And Ms. Nahara says, direct and cross, I'd say 15 minutes. Ms. Abramson says, and then there's an issue with respect to Sergeant Edmonds. The court says, I don't want to get to that yet. Ms. Abramson says, okay. Court says, well, let's do this. We'll start and we'll don't bring this subject up regarding the statement of Lyle Menendez to Mr. Berman at the outset. Maybe we'll take a break in the middle of his testimony to deal with it. Ms. Nahara says, okay. The court says, we'll take a recess now until a quarter after, and then we'll start. A recess was taken from 9:15 to 9:20. Now Mr. Levin has a little more to say after the recess. Mr. Levin says, "Yes, Your Honor, this is my request. Several moments ago, I attempted to have a discussion with Mr. Berman, who was out in the hallway, very cooperative, more than willing to talk to us about his testimony. First, this is Lyle, I'm sorry, this is Eric's, Barry Levine is Eric's other attorney. First, I was talking to him. The gentleman from the prosecution's office was seated or was standing directly a few feet away from us listening to our conversation, and he refused to leave and give us the privacy that we wanted to when we wanted to talk to Berman. That's a problem with the prosecution's office. The gentleman from the prosecution's office. So who's that again? We've got Gil Garcetti or David Kahn. It's one of them. Probably David. I don't know if Gil is even in the courtroom. Um, well, we'll look because it should say who's present, right? Yeah, for the people, Gil Garcetti is there. But I don't know. That still might not mean that he's present. I don't know. Okay. Anyways, continuing on. First, I was talking to him, the gentleman from the prosecutor's office. They wouldn't move, and he refused to leave and give us privacy. After that didn't work, a few moments later, Mr. Berman still talking to us, Ms. Nahara comes storming up to Mr. Berman and myself and starting to say that we don't have any right to talk to Mr. Berman. That if it was that Mr. Berman is her witness and that she refused to let us talk to Mr. Berman in privacy. That's not how this works. She doesn't get to dictate that. This is not right, and we assume that Ms. Nahara is going to continue with this activity, and we would really ask the court to have a cease and desist. But more importantly, what we would like now is a few moments before the jury comes out to have the opportunity to talk to Mr. Berman alone, as is our right to do so. Ms. Nahara, Your Honor, or Ms. Nahara says, Your Honor, if I may respond briefly. The court says, all right. Ms. Nahara says, first of all, Your Honor, I object and take umbrage with the characterization that anybody went storming up. I was informed that several of the defense attorneys were talking to Mr. Berman outside. I had not had a chance to talk to Mr. Berman this morning, and as Your Honor said earlier, that would be something that would be more than appropriate. I went up to join them. Mr. Gessler, Mr. Levin, basically ordered me to leave. I explained to him that I am calling a witness who is a case in chief witness of ours, and were the positions reversed, and I talking to him, one of his case in chief witnesses, he would not hesitate to come up and not leave. I explained to him that as far as I knew, he had no absolute right to talk to a witness without my being present, and I asked him if you know of anything different, um, please point that out to me. He didn't. All he did was say, You're being rude, and walked away. And that is how that situation actually occurred. Like, okay, yeah, you sound like a mean girl. You sound like at you're at fault here. You're not making your case. Now, our position is that we're going to call Mr. Berman in a few minutes in our case in chief. As far as I know, the defense does not have an absolute right to talk to him in privacy. If I'm wrong about that, I'll be more than happy to apologize, but I don't think I am. And I don't think anything inappropriate has been done except the defense is refusing or trying to make up very new rules for a very old game. Ms. Towery says, Your Honor, I was present when Mr. Levin was talking to Mr. Berman, and I think that from my perspective, his description of what occurred is accurate. Uh-huh. So, Levin's description is accurate. And secondly, I want to point out to the court that Mr. Berman did indicate that with respect to, well, I don't know what he said to Detective Zoeller. Ms. Abramson indicates that he indicated something to Detective Zoeller in the hall, but he did indicate to me and Ms. Abramson that with respect to the conversation about disinheritance, His best recollection is that he had that with Christie and not with Lyle. Ms. Abramson says, yes, Your Honor. When we walked out on the break, Mr. Berman was sitting by himself. There was no prosecutor trying to prepare him or talk to him, and I asked him if he had just had a conversation with Detective Zoeller. He said he had, and he said Detective Zoeller had referred him back to his March statement and had asked him whether the remark about disinheritance had come from Lyle or had come from Christie, which was the proper way to ask the question. And Mr. Berman told me that he had told Detective Zoeller that his best recollection is that it came from Christie, and there was none of the prosecutors were out there trying to talk to the witness at that time. And then Ms. Towery and Mr. Levin took the witness aside. I was across the hall talking to Detective Zoeller, and I saw Ms. Nahara storm over to where Ms. Towery and Mr. Levin were talking to the witness. I should also point out, Your Honor, that last night after court we had an appointment to interview a witness in our case in chief, who was Mr. Ron Linhart in the Sheriff's Scientific Services Bureau, and we made that appointment and we got there and prosecutors were there and we went ahead and we had our interview in the presence of the prosecutors. That's really bizarre. That's weird. Why were the prosecutors there? So apparently the rule is prosecution gets to be there no matter whose witness is being interviewed, ours, theirs, anyone's, but we don't. The court says that wasn't the point. The point was whether or not you would be interviewing this witness without the prosecution's presence. Ms. Abramson says it's purely up to the witness. If the witness wants to have someone present, the witness can. If the witness doesn't, that's the witness's decision, not the prosecution's or the defense lawyer's, as far as how interviews are concluded. If the witness is willing to speak with someone alone, then that's up to the witness. There's no grounds for rules one way or another other than what the witness wants as far as others present. Certainly, no one has a right to be present or not to be present. It's up to the witness. Mr. Levin says, Your Honor, the court says, as far as interview of the particular individual, as I understand it, the last interview was concluded in March, so the issue that you brought up now was something that everyone was aware of since March, and he could have been interviewed uh, those these many times, these many months. I don't know what that is. That must be a error. These many months, and nobody bothered to do that on this particular subject. So that's your problem. But he's here now, and I don't see any reason to delay the proceedings any further to have an opportunity for an interview that could have been conducted months ago. So now he's blaming basically the defense, like you should have asked this. Like what? No, sir. Are you going to do something about the rude prosecutors that won't let us talk to their witnesses? No, he's going to blame Levin, cut him off, and say, well, it's your problem now. You didn't deal with this before. Ms. Towery says, well, Your Honor, based on his statement to Detective Zoeller that was set forth in the police report, that statement would not be admissible. Our concern was that the prosecution might seek to elicit it in any event. The court says, what is the people's position now? Ms. Towery says, which apparently they were going to do. Ms. Nahara says, Mr. Berman told Detective Zoeller that he was not sure who told him that information, whether it was Lyle Menendez or Christie. He said if pushed, he would say it was Christie. Now, based on that statement, we won't be eliciting the statement. The court says, all right, let's get the jury out and we'll proceed with the testimony. And that is where we will stop for now. And we will continue on with testimony. If you guys want it, we will continue on with Avril Crom. Who else do we have on this day? Perry Berman, which we will definitely do, and Sergeant Thomas Edmonds, if you would like his testimony as well. So I will look for those polls, make sure that you vote so I know whether to read those or not. And we will continue on. I'm here for reading through this whole thing. If you guys want it, I will. I mean, it's interesting to me, so and I kind of like the comparison of from trial 1 to now to this trial. So, let me know what you guys think. If you want me to read through everything, I'm fine with that. If we should just stop polling and just read through it all, I'm fine with that too. So let me know in the comments below what you think, and if you want me to read Avril and Sergeant Thomas Edmonds. I will see you guys in the next one. Take care. Thank you so much for watching. Have a good one. Bye now. Whoops.